Hello, everyone. Thank you so much for joining us today as we get started on this boot camp for education technology vendors. I'm so happy to be welcoming you here today. My name is Miles Light. I am a policy counsel at the Future of Privacy Forum and one of the members of the youth and education team. We take privacy very seriously here at the Youth and Education team. And one of the things that we really get jazzed about are the opportunities to be able to speak to you as an audience about these changing compliance issues that you're facing. We hope to have a really wonderful program for you today, but I do want to say that this is part of a larger series that we're going to be putting on with boot camps for this audience for education technology vendors. And in the interest of creating something that's the most responsive to you, one of the things that we'll be doing towards the end of the day is collecting a survey just to get a sense of your interests and to see what level of information would be the most helpful to you in future sessions. Now, moving on to today's session, we're going to have quite a few wonderful speakers that are going to talk about the changing landscape of education technology compliance in the student privacy space. Now, I'm sure many of you are aware of changes that are going to be occurring at the federal and the state level, but we have speakers that have been tracking these changes and are hopefully going to be able to give you some enlightenment on where education technology compliance is going to be headed in the coming years. We will end up having a few panels on this, and we highly encourage everyone to participate in question and answer as part of this. If there are burning questions that you have, each of the sessions, we will make sure that we have some time to be able to get into your particular questions that are coming up as we're moving through this content. Now, I wanted to start off by saying that change is really one of the themes that we'll be talking about today, and a lot of what we'll be highlighting in these sessions will be updates and changes in legislation, regulatory thinking, potential enforcement actions in the future. All this is to say that we have, I think, a wonderful opportunity to delve into some of the things that you may have concerns about in the future. And we want the opportunity to have a very open conversation with the panelists, with you, about the content that really is the most important for your compliance obligations. When we move on to these sessions, I would just note that we will have breaks in the middle. So we'll probably speak for about 45 minutes each time, try to move on to a break. So you will have opportunities to be able to stretch your legs throughout the day. I want to also highlight some work that we've done recently at the Future of Privacy Forum, as I think that it's a good companion to the content that we're going to be going over today. But recently, we've had publications on the Age-Appropriate Design Code Act that recently passed in California, and some analysis of what requirements are contained in that act. We also have publications out about the recent push for federal children's privacy and online safety legislation, including analysis of the original COPPA rule as it currently exists, and then comparisons with the amendments that are being considered in Congress to COPPA. The last thing that I wanted to highlight is we have had a fair amount of work that we've been doing in immersive tech. One of the things that we will be discussing later on today is the work that FPF has been doing in immersive technologies. And by immersive technologies, I really am talking about the application of XR, AR, VR in a variety of use cases. One of the use cases that FPF has been tracking is their use in education technologies and the potential use cases in the future for education. So one of the things that we wanted to highlight was that work in case there is any desire, need to look at the type of privacy harms and privacy considerations that are coming up in that space. So without further ado, I do want to get started on the real content, the meat and potatoes of the day. And I think we have a great presentation first off. In this space, COPPA and FERPA are two of the most important laws. They're both federal laws, and while many of you have had experience with them, we wanted to get started with a discussion that really started from ground zero with them, as they will form the basis for the rest of our discussion for the day. So I'd like to introduce you to Sophie Baum. Sophie is an associate at Hogan Lovells, who works in this space and a really wonderful practitioner. She has a presentation for you today, and I'm so excited to have her be speaking to you all.
Great. Well, thank you so much, Miles, and it's nice to speak with everyone. Good morning from Denver, where it is snowing and also early. So if I say anything that doesn't make sense, I'm going to blame it on the fact that I have not yet had my full cup of coffee, and hopefully you all will forgive me. As Miles mentioned, I'm an associate with Hogan Lovells in our privacy and cybersecurity group. A large part of my practice focuses on student privacy, children's privacy, online safety, among other issues. So can go ahead to the next slide. Right, so this is what we are planning to cover today. I think this introduction session focused on COPPA and FERPA is really meant to set the landscape, kind of give you an idea of where the rest of the discussion for the boot camp today will go. So we'll be covering kind of basic principles, you know, what is COPPA, what is FERPA, what are some, and we'll touch briefly on some of the recent federal developments, although I know that there are sessions on that later in the day, so we won't spend too much time on that. And then we'll open it up at the end for a couple of questions if you all have anything you'd like to discuss. Okay. Yeah, that's perfect. Thanks. So COPPA and FERPA. Congress enacted the Children's Online Privacy Protection Act, COPPA, in 1998. So it's been around for a while, and it's been around, you might realize, since almost the beginning days of the internet. COPPA required the Federal Trade Commission, the FTC, to issue and enforce regulations concerning children's online privacy. The Commission's original COPPA rule became effective in 2000, and there was an amended rule that was published now several years ago in 2013. A couple of things I want to talk about during this presentation on COPPA, but one of the things to highlight here is that many federal privacy laws do not apply to nonprofits, and COPPA is one of those. So when you think about whether it might apply directly to a school, for example, or to any other nonprofit, the answer is no, but it will apply to EdTech vendors and other private companies. The FERPA, the Family Educational Rights and Privacy Act, is enforced both by the FTC, but really primarily by the Department of Education, and it governs the collection, use, and disclosure of student records. And while it does apply primarily to educational institutions like schools or districts, you'll see as we talk through this presentation that there are certainly effects and considerations to keep in mind for EdTech vendors when it comes to FERPA as well. We can go ahead to the next slide, please. Oh, actually, let's go back one. Oh, can we go back one? Sorry. Thank you. That's okay. We can. Here's good. I just wanted to talk. Issues. No, this is all good. Just wanted to talk really quickly about the COPPA rule and give some background for folks who might not be attorneys in terms of what is COPPA, the statute, versus COPPA, the rule. And bear with me as we do just a really brief mini session on administrative law, which I know everybody wants to talk about first thing in the morning, but it's helpful to kind of understand the framework here. So when Congress passes a law, a statute, it might say in that law, X agency, in this case FTC, has authority to write and promulgate regulations that will implement the law. And so those regulations would include, additional details or obligations for what covered entities need to do under the law. So when we talk about the COPPA rule, what we're really talking about is the regulations that the FTC has promulgated, the more specific obligations that are in those, and the fact that it is more easily able to be changed than the COPPA statute itself. And we're not saying that it is easy to change, right? There's a whole process that goes into amending a rule versus passing or amending a law through Congress. But some of the flexibility that comes with implementing and enforcing these statutes comes because there are implementing regulations that are kind of supplemental to the law itself. So just wanted to make that distinction. And when I refer to COPPA throughout this presentation, I'll be referring both to the statute itself and to the regulations. So COPPA basic principles. COPPA applies when there is actual knowledge that a site is COPPA applies in two situations. Let's kind of start there. Either where there is actual knowledge or where a site or an online service is directed to children. And actual knowledge has kind of two subcategories. So actual knowledge applies when a site or service, an operator has actual knowledge of their own collection. So when they know for a fact that they are collecting, using, disclosing personal information from children under 13. But it can also apply when that operator has actual knowledge that they are collecting that information from another site. So when they have actual knowledge, they're collecting personal information directly from users of another website or online service that's directed to children. And how would you know that you have actual knowledge? One way, for example, might be if you ask for users' registration, or during the registration flow, when you ask for their age and they say, I am 11, that would be a pretty clear indication that you have kids under 13 on your site. The other way that it applies is when you have a site that is directed to children. So COPPA applies to operators of commercial websites and online services. And I want to pause on that term and make sure that it's clear that it's not just websites, but that it also applies to things like mobile applications or internet connected devices. So just keep that in mind kind of throughout the course of this. But COPPA applies to operators of those sites or services directed to kids under 13 that collect, use, or disclose personal information to children. And I want to talk about this term directed to children because it's not always 100% clear when a site or service is directed to children or not. But when determining this, the FTC looks at a variety of factors. And when you're determining this for yourself or for your companies, you should also think about these factors to help determine whether your site or service is directed to kids. So some of the things that you might look at are the subject matter of the site. Is it a game, for example? Is it EdTech, maybe? The types of visual content on your site, whether you use animated characters, child-oriented activities or incentives, child celebrities or celebrities who appeal to children. Is there advertising that promotes your service to children or appears on other websites directing kids to your site? So those are some of the factors to consider when determining whether your site is directed to kids. And the FTC also looks at whether or not you have evidence that you've gathered internally that might suggest audience composition. So whether you've done a study to try to figure out who are the users on your site, and it turns out that it is a lot of kids, and that is kind of the intended audience for your site, then you might have a situation where you have a site that is directed to children. And you might have a site that is a mixed audience site where some parts of it are directed to children, but not other parts. And you need to be aware of that as well. Next slide, please. Okay. So here are a number of requirements that COPPA covers. And I'm going to touch on a couple of them, but I just want to say kind of at the forefront of the slide that there are a variety of kind of requirements that come within each of these sub-bullets. And so what we'll talk about today is maybe on the surface of what some of these require, but you should definitely talk to folks in your companies, talk to your attorneys, talk to your outside counsel if you need to get a better sense of what is required for each of these obligations under COPPA. So we can start with privacy policies. And as you'll see, there's a requirement to provide a privacy policy with certain details and certain requirements. And some of these, a lot of these might be met by your general website privacy statement. So the privacy policy that you have in the footer of your app or of your website might already cover some of these, but you do want to be conscious of them and kind of make sure that if you do have, if you are covered by COPPA, that these are taken into consideration for your website privacy policy. So some of the things that would be required for these policies include a list of third parties on who's collecting kids' personal information on your site, a description of personal information and how it's used. This might include, for example, the types of PI, how it's collected, like through cookies or tags, for example, through direct input in a web form, how the information will be used and how it will be disclosed. Another item that you're going to want to have in your privacy policy is a description of parental rights, which are granted under COPPA. And so these include that parents can review their child's personal information, direct a website operator to delete it, refuse to allow any further collection or use of children's information, and also procedures to exercise these rights. So that might be as simple as, click here to email us to request exercising your rights, but you're going to want to describe to parents how they're able to exercise those. The next bullet on here, verifiable parental consent, there's a kind of a notice element to this as well. There's a notice and consent framework here. So I'm going to touch on notice briefly. COPPA requires that operators give parents direct notice of their information practices before collecting information from their kids. This might also require notifying parents if, for example, you give the initial notice, you say, here are my practices, but then there are material updates to those practices, you may need to go back and re-notify parents. These notices have a couple of requirements. For example, you have to explain what the notice is, that you're requesting consent to process kids' information, the reasons why you want to process that information, and a link to your privacy policy so parents can go and get more information about your processing of the information. And consent, you have to give parents an opportunity to provide consent to the use of their kids' information. And this is a big one. And there are exceptions, and we're going to talk about some of those kind of throughout the course, especially in the school context, the course of the presentation today. But I want to touch on consent because it is sort of the basic underlying principle of COPPA, which is that parents need to give consent for the use of the collection and use of kids' data. The method of consent is not prescribed by the FTC necessarily, but they do have guidance saying it should be reasonably designed in light of the available technology to ensure that the consent is given by the child's parent. So you might rely on something like email consent. There are more robust methods that you can look at, like requesting a form of government ID. COPPA also allows for the use of a credit card or other online payment system that provides notifications to account holders, essentially with the premise that adults are likely to have credit cards and children under 13 aren't, but kids these days, who knows what the kids are up to, they might have credit cards. So essentially, COPPA also allows for a method called email plus, and you may have heard that term. And that is if you are collecting a child's personal information only for internal purposes, that is, you're not going to further disclose it. You can use this email plus method in order to get consent. And under that method, what would happen is you would send an email to a parent, have them respond with their consent, and then you send a confirmation to the parent, and it can be via email or letter, or I think phone call as well, if that is the route that you choose to go. And if you use this method, though, you have to let parents know that they can revoke their consent at any time. So that was a lot of kind of detailed information about consent, but what I really want to highlight is that there are exceptions to consent. So you're not going to be in a situation, especially as an EdTech vendor, where every single time a kid comes on your site, you have to get consent. You might be able to rely on one of these exceptions. So one example of an exception is if a child writes in with an inquiry and a one-time request. For example, if the child has a question about how to operate the site, you're able to kind of respond to that without getting consent. You can also forego the consent if the purpose of collecting and processing the children's information is to protect the security or integrity of your site or service, to take precautions against liability, if judicial process is involved. For example, you have a subpoena, or to provide information to law enforcement. And then another big exception that we see EdTech vendors relying on in certain situations is if the information is needed to provide provide support for internal operations of your site or service. This includes items kind of day-to-day. Think about this as day-to-day business operations. So maintaining or analyzing the functioning of your site, performing network communications, authenticating users, serving contextual ads, protecting the security of your site, legal or regulatory compliance. So there are a number of these exceptions that you're going to want to be thinking about as you go through the process of collecting kids' information and thinking about how you're going to use it, and what data elements you're collecting. Next slide, please. Thanks. So COPPA can be enforced both by the FTC or by state attorneys general, and you see them often partnering up. So kind of one of the most famous COPPA settlements was in 2019 against Google and YouTube, and there was a $170 million penalty, which was certainly the largest to date at that time. And this is an example where the states and the FTC joined up. So 136 million went to the FTC, and a $34 million penalty went to the state of New York. Now, $170 million is a lot for a COPPA penalty. And generally over the past years leading up to that, and even still, we've seen penalties range roughly from 1 to 6 million. For example, there was a settlement against TikTok in 2019 for 5.7 million, again, based on an alleged failure to gain parental consent. There was a settlement in 2018 against Oath, which was previously Verizon, and owned by Verizon, previously AOL and Yahoo, where they paid 4.95 million. And so we see these penalties kind of in this range. But one of the things about COPPA is that the FTC enforces not just with monetary penalties, but also with penalties that impact organizations and their operations. So, for example, in December of 2021, so more recently, there was a $2 million penalty against OpenX Technologies, which was an ad platform. Again, allegations that the company collected personal information from children under 13 without parental consent. There was a separate allegation that despite offering an opt-out option, OpenX collected geolocation information from users who had asked to be opted out. So they were hit with this $2 million penalty in their settlement. But in addition to that, the order required that OpenX delete all of the ad request data it had collected to serve targeted ads, and required that it implement a comprehensive privacy program to ensure that it complied with COPPA. Another example of this, more recently in March 2020, the company WW International, previously Weight Watchers, they received a $1.5 million penalty. But importantly, the settlement required that they delete personal information that the FTC had alleged that they collected illegally from children under 13. And they also had to destroy algorithms that they derived from that data. So we are seeing a trend, not just of monetary penalties, but also towards potential impacts for businesses. And so as you are designing your COPPA compliance programs, you're going to want to think about really carefully, what are the potential penalties that might come, and what are the risks if I don't align my program with some of the requirements that the FTC has put out. Okay, next slide. This would be an excellent, that would be an excellent question to ask. And we are going to cover it in a moment, but I just want to put it in your minds because you can go ahead to the next slide, actually, Miles. Perfect, thank you. You might be asking how COPPA applies in schools. This is an EdTech vendor training, and so we want to focus on what are your obligations in that role when it comes to students in the online services and school world. So there is an exception for COPPA, and the FTC has recognized that it would not be practical for every service provider, every vendor to gain consent for every student in school, because often there are issues with you can't even get an entire class's permission slip, right, to go on a field trip. Trying to get every vendor to get parental consent would be very difficult. And these are essential tools that are used in classrooms that help kids with learning, help teachers with administrating their classrooms. And so the FTC has sort of paved a way for EdTech providers and for other service providers to get consent in the classroom. And something you'll see this asterisk at the top and then explained at the bottom. This is not an exception that is codified in the rule or in the statute. This is contained in the COPPA FAQs, which, if you all are not already familiar with them, we'll be referencing them today, but I would highly encourage you to go on the FTC's website and go through those FAQs, because that guidance is a lot of the basis that the FTC uses when it interprets the COPPA rule and when it enforces. So essentially, what this slide does is discusses what an operator must do in order to rely on consent obtained from the school under COPPA instead of the parent. So if you could go to the next slide, please. This is the slide that I had previously thought was coming up next, but yes. We can stay on it. We can stay on the green slide. Perfect, thank you. I want to put this in your minds because this is something that is going to come up in just a couple of minutes, but there is something called the school official exception to FERPA. And while this exception, or exception in quotes again, because it's not codified, but the COPPA exception, what I want you to kind of think about it when we talk about the FERPA school official exception, because there are parallels, and I just want to kind of plant that seed for you. So we can go ahead now to the next slide. Perfect, thanks. So as I mentioned, these are the things that an operator must do in order for an operator to rely on consent obtained from the school under COPPA instead of from the parent. So the required notices to provide to the school are the same type that you would provide a direct notice to parents. So regarding your practices on the collection, use, disclosure of personal information from children, in the sort of pure COPPA context, you would provide those to the parent. But here, if you're relying on this exception, you would provide those notices to the school itself. And as long as the operator limits the use of the children's information in the educational context to the extent that it's authorized by the school, which you should be doing in any case if you're operating under FERPA, the operator can presume that the school's authorization is based on the school having obtained parental consent. In other words, you don't need to go back and triple check that they have permission for every single student. You can kind of assume safely that the school has obtained the appropriate consents. This is something you likely will see in your contracts and your agreements with school districts. There'll be a provision addressing this directly. Next slide, please. So this is also from the COPPA FAQs, and I won't read all of these, but essentially these are considerations that schools and districts will be thinking about when deciding whether to engage a third party. So these are things you should be thinking about, knowing that they will come up likely as discussion points with schools and districts when you're negotiating your agreements or considering the implications of COPPA. Next slide. Okay. Similarly, these are things that you should be prepared to discuss both in discussions with schools and districts and also in your contracts. And so this is kind of a checklist of questions when a school is thinking about whether to engage an EdTech vendor that you're going to want to be prepared to address and discuss with them. So again, not going to read through these, but you all can have these as a reference point. Okay. I'm going to take a break for just a second, have some coffee, and we're going to dive into FERPA. FERPA. So we just covered COPPA, which applies again to online sites and services kind of generally. And you might, whether or not you're an EdTech vendor, you might have COPPA obligations. FERPA is an education-specific law governing student records. And so, again, I mentioned at the beginning of this presentation, it applies kind of primarily to schools and districts, educational institutions, but there are implications for EdTech vendors. So I want to talk through a couple of key terms that are gonna inform the rest of this part of the training on FERPA. So the first is personal information or personally identifiable information. Now, this term under FERPA includes things that we are all kind of used to being personal information. So it could be the name of a student or a student's family members, their address, personal identifiers like social security number or a student assigned student number in the school context, kind of those direct quote unquote identifiers, and also indirect identifiers like a student's date of birth, their place of birth, their mother's maiden name. And then there is this catch-all bucket of information, and it's other information that alone or in combination is linked or linkable to a specific student. And then there's a second part of the definition that would allow a reasonable person in their school community to identify the person with reasonable certainty. So I just want to highlight this because this is a way that a lot of information that we may or may not think about as PI in the FERPA context can get swept in. And so you really want to be careful when you're thinking about the data elements that you're collecting about kids in the school context, whether or not they might fit into this broader kind of catch-all personal information bucket. And information requested by a person who the educational agency or institution reasonably believes knows the identity of the student to whom the education record relates is another element to keep in mind, but that one is, you probably won't encounter that one as much. De-identified data. So importantly, when we think about PII versus de-identified data is not the same as PII. As a general rule, there's no common standard or requirement by the Department of Education for how to de-identify student data. It's really a determination based on the facts and circumstances. But if you are relying on de-identified data to do, the processing that you need to do, you want to make sure that you've taken appropriate care, that it can't be re-identified, that it's not traceable back to individuals. Now, the reason you might want to use de-identified data, or the reason that EdTech providers do use it, is that because, and I know we touched on this and we'll talk about it more in a second, as a general rule, FERPA prohibits the disclosure of education records containing personally identifiable student data without consent from the parent or the eligible student. So the release of education records that have been appropriately de-identified, that is, they have none of these direct or these indirect identifiers that we just talked about, does not count as a disclosure under FERPA. There are other benefits, like these records are not subject to deletion requirements, although the Department of Education encourages deletion in any case. So there are reasons and ways that you might want to use de-identified student data, but you want to take care to make sure that it actually is de-identified. And school official, we are going to talk about that kind of in length in just a couple of minutes, but I want to put this on your radar. When there are disclosures to third parties, it could be that those third parties, namely EdTech vendors, are functioning as what's called a school official, so functioning in place of the school to provide certain services. So we'll talk more about that one in a second. We can go to the next slide. Thanks. So as you'll see, FERPA grants parents certain rights that they have until they reach 18. I'm sorry, until their child reaches 18 or their child attends a program beyond high school. So if you have a 17-year-old college student, technically the rights would transfer to that student at the time they leave high school. Schools must notify parents and eligible students every year about their rights under FERPA. There are certain, means of notification schools can use, letters, handbooks, what have you, but that's left to the discretion of the school, and it's not something that EdTech providers would be doing, but rather something schools would be responsible for. Next slide. So generally, schools must have written permission from the parent or the eligible student in order to release any information from a student's education record. Under FERPA, the covered educational institution, the school, is not permitted to disclose PII from students' records without parental consent unless an exception applies. And this might ring a bell from COPPA, baseline requirement of consent unless an exception applies. And we'll talk about the school official exception in just a second, but the U.S. Department of Education, which we talked about enforces FERPA, takes the position that collection of a student's PII by a third-party online educational service or on behalf of the school constitutes a disclosure of PII. So what that means is when a school sends information to an EdTech vendor, in general, the department considers that to be a disclosure. So that results in the covered school either obtaining parental consent or relying on an exception before they're able to provide information to an EdTech vendor in an educational setting. There are a couple exceptions here that I want to touch on briefly that you might encounter before we talk about the school official exception, which is sort of the main one here. But you'll see there's something called the studies exception, where there's a disclosure of PII from student records from a school to an institution in order to conduct a study like something to administer student aid programs or to develop predictive tests for students. There are certain rules that come along with this exception, and it's fairly limited. So information needs to be destroyed after the conducting of the study. There are certain written requirements, written contracts that you have to have in place in order to take advantage of this. So It's not really a general exception. It's something that you would use in a more targeted setting. For example, if you are a vendor that assists with these kinds of things. And then you'll see this final bullet on the page, directory information. And the way I think about directory information is the type of information you would find in a student directory or in a yearbook. So this can be disclosed without consent. So in other words, the school can disclose this without consent, but schools have obligations to kind of notify parents and students and allow them an opportunity to not disclose it. So to the extent you're an EdTech provider, you can also disclose this information, but you want to be careful about making sure that you're not disclosing information that is not directory information. So we can go to the next slide. The FERPA school official exception. I feel like we're finally here. I've been teasing this. I'm sure you guys are just like on the edge of your seats waiting to hear about this. So under FERPA, a school official is a party, and that includes EdTech vendors, it includes contractors that meet 3 criteria. So number one, the party performs an institutional service or function for which the agency or institution would otherwise use employees. Number two, the party is under the direct control of the educational agency or institution with respect to the use and maintenance of education records. And number three, it's subject to similar limitations as the educational institution with respect to the use and redisclosure of student PII from education records. So I'm going to kind of break down each of these prongs, talk through them. What do they mean, and how can you know if you are a school official? And so the first prong is institutional service or function. So the Department of Education, again, which administers FERPA, has not provided an exhaustive list of activities that qualify as educational services, but it has released guidance. And in that guidance, it identifies a number of objectives that it considers to be legitimate educational purposes. So for example, if you are assisting with the personalization of learning modules, the improvement of online services offered to educational institutions, those both qualify as activities that might otherwise be institutional services or functions. Excuse me. The department's guidance also identifies not only these things that would be in service of the school, but also identifies a couple of activities that they would not typically consider to be legitimate for educational purposes. These include targeted advertising, the sale of student data to third parties, the use of personal information to create new products or services in order to market them to schools or districts. So the second prong, direct control by the district or school. So in order to satisfy this control requirement, the Department of Education has released guidance, and they advise that there are a couple of conditions in place. Now, the first one is that the online service provider should be restricted from using PII for unauthorized purposes, that is, purposes that the school does not directly instruct them about. And then the department also says that while a contract is not strictly required, direct control can be established through the use of a contract, such as terms of use or a separate DPA that make clear that schools and districts have final control over all student PII generated through the use of the service. Now, this includes archival and destruction requirements, and they also want to make sure that the disposition of PII maintained by the service provider is under control of the school. So essentially, you can't do anything with it unless the school tells you that you can do something with it. And you'll often see this sort of magic language, again, I'll put that in quotes, magic language in contracts that will say, you know, XYZ EdTech vendor is under the direct control of the school. And that is the FERPA language that you're looking for in order to kind of satisfy this prong. And one of the reasons for this is that schools and districts want to make sure that they are able to provide parents or eligible students who request to exercise their rights with access to their student PII records, the ability to correct that information, So they don't want to get in a situation where, for example, an EdTech vendor says we have all this data about students and they're offering to exercise their rights on it and the school can't access it. That would be bad. That would be contrary to FERPA. And so that's kind of what this prong is intended to get at. One nuance of this before I move on to the third prong, and one question that might arise is whether individual teachers have the ability to agree to the terms of service or the privacy policy or the DPA that you as an ed tech vendor might have with the school. So while both the FTC and the Department of Education encourage the educational service providers, the ed tech vendors, to enter into agreements with school districts or schools instead of individual teachers, technically it is not prohibited. So you can enter into agreements with teachers, but the sort of prevailing guidance is that the federal government would prefer if you deal with these institutions on a higher level, either the school level, the district level, what have you. So the third prong, and I know we're running a little short on time, and I want to make sure that I leave room for questions at the end here. So feel free to follow up if we don't manage to get through everything. But the third prong, limitations on use and redisclosure. The questions that you're going to be asking here is the vendor subject to limitations, to the same limitations as the educational agency on the use and redisclosure of PII? So you're not going to have an agreement that says, vendor, feel free to use this information for whatever you want, even purposes that the school cannot use it for. That won't happen. And for example, one of the restrictions you'll often see in a contract is that the vendor is restricted from selling student information to third parties for those third parties' own uses. We can go to the next slide. Next slide. The answer is yes, they do. COPPA and FERPA overlap. And so we just talked through COPPA and we just talked through FERPA. We saw those exceptions for consent that ed tech vendors are likely to be using in the context of offering services to schools. And so there is an intersection here. And the Department of Education has established kind of what they call the Privacy Technical Assistance Center, or PTAC. You can Google that, you can find their guidance. And essentially it recommends, and what some of the PTAC guidance recommends is that districts are aware of the educational services that are being used, that they have policies and procedures in place to evaluate the educational institutions and to evaluate their contracts in terms of service to ensure that they align with FERPA obligations. So where you'll see kind of this convergence is that second bullet. So service agreements, terms of service, guidelines, they might include provisions imposing obligations on schools to obtain COPPA consent. And that is the first bullet, or the first exception that we talked about with COPPA, again, that FAQ exception. So it's not practical for parents to obtain consent for every single student. So while you might have an agreement or a DPA with the school that sets forth that, I am a school official, I am subject to use restrictions and collection restrictions, and I am under full, control of the school, you'll also have provisions that you're going to want to make sure are in that DPA, in that agreement, that put the obligation for obtaining consent from these students to the extent that you're dealing with under 13s on the school. Okay. Next slide. We can move on. Yeah, perfect. Thank you. So there have been a number of developments on the federal level. And you'll see I have just 2 bullets here because I understand there are sessions later in the day, and I don't want to get too deep into it. I think the panelists later today are going to have a lot to say about developments. There are certainly developments in Congress One that I'll just mention briefly is the Children and Teens Online Privacy Protection Act, or COPPA 2.0, which would extend COPPA to individuals under age 16 instead of 13, and impose other obligations and restrictions like banning targeted advertising to children. Again, not going to get too far into that because I understand you'll be discussing it later, but there are a couple FTC related updates that I want to share with you all, and that I want to make sure that as ed tech vendors you are aware of. And I guess we can start with this second bullet, and it says COPPA rule update ? And the reason is, as we mentioned, COPPA was enacted in 1998. The rule was last updated in 2013. Back in 2019, in the before times, the FTC initiated a review of the rule, and that review essentially was to kind of gather public comment and say, should we take a look at the COPPA rule? Should we update it? And that review is still pending today, which is a little unusual to have a rule review out for 3 years. In the fall of this year, a couple of months ago, some members of Congress, including those who are really engaged on children's issues, Senators Markey and Blumenthal and Representatives Castor and Trahan, wrote an open letter asking the FTC to take a look at the COPPA rule. But there hasn't been a lot of movement. And in fact, just a couple of weeks ago at IAPP, at PSR down in Texas, Commissioner Slaughter from the FTC was asked about the rule update and asked if she had any news to share about where it stood. And she mentioned that she didn't have any updates on the COPPA rule review, but she strongly encouraged folks to comment on the advance notice of proposed rulemaking, which has to do kind of more broadly with online issues and has a section kind of dedicated to children. So a lot of folks interpreted that to mean that the COPPA rule update was sort of on the back burner for now. And that's possible. And it's possible because, as I mentioned, there are a lot of developments that might be happening at the federal level. And so it's the FTC, one of the theories is that they could be just kind of waiting to see what happens with the statutes, whether COPPA is extended. And it's not because they don't care about the COPPA. They certainly care about COPPA. They care a lot. They care about kids' issues. Commissioner Bedoya, the newest FTC commissioner, has been really outspoken on children's issues. And because the rulemaking authority that the FTC has under this proposed rulemaking versus under COPPA is different, it could be that they are just waiting to kind of see how that all shakes out. So potentially a COPPA rule update, but nothing to share on that yet. And it may take a different form than we are expecting, kind of based on what happens in Congress. So I'll talk now just briefly about this first bullet, and then we can leave a couple of minutes for questions. Policy statement of the Federal Trade Commission on Education Technology and the Children's Online Privacy Protection Act. Big title, but also a big deal. So earlier this year, the FTC released this policy statement specifically directed at ed tech vendors. And it noted that due to COVID, there had been kind of an uptick in online learning, educational technology in the classroom. And the FTC made it pretty clear that they were concerned about how ed tech vendors were collecting and using children's information, whether they were building profiles about children, whether they were using those profiles, selling that data, potentially using it to advertise to children in a way that the FTC didn't like. So they're kind of signaling to everyone that they are serious about kids and serious about vendors complying with COPPA in the classroom. So this policy statement covered a couple of topics, and I'll just touch on those briefly. The first is a prohibition against mandatory collection of information. So what this policy statement says is that ed tech vendors should not be conditioning a child's participation on the disclosure of personal information. So if they don't need it for the provision of the service. So you should not be offering a product in classrooms and then saying, by the way, we also need your email address and your home address and your parents' occupation and your parents' income or any of that information if you are not going to be using that for the provision of the service, which is aligned with FERPA and with the expectations in your role as a school official in any case. But again, this is kind of a COPPA directed policy statement. The next thing that this policy statement covered was use prohibitions. So not only should EdTech providers, according to the FTC, not be collecting that type of information, but they should also be strictly limited in how they can use the personal information that they do collect from kids, even if it's necessary for the provision of their service. So a quote that I'll read just from the policy statement says, EdTech companies are prohibited from using information for any commercial purpose, including marketing, advertising, or other commercial purposes unrelated to the provision of school requested online service. So again, they're kind of doubling down, making it really clear that in their view, in the FTC's view, this information should only be used for purposes of schools or providing services that the school request. Two more big buckets that this policy statement covered. The first was retention prohibitions. So it says that COPPA covered companies cannot retain information from kids for longer than is reasonably necessary to fulfill the purposes for which it was collected. And you want to think carefully about this as an EdTech provider, because often you might get pressure from folks in your organization to retain information, to use it for R&D, to have it as a backup, for a host of reasons. And you want to think carefully both in terms of your practices and your contracts, how it's going to be, how long it's going to be retained, and whether or not you really need that information for the provision of your services. So the final bucket that the FTC covered in this policy statement is security requirements. And they say that COPPA covered companies must have procedures to maintain the confidentiality, security, and integrity of children's information. And even if there is no data breach, failing to have procedures in place might violate COPPA. And this final one, the FTC is serious about, and we have seen enforcement actions against a variety of EdTech companies, but one just last month, actually in October, where the FTC cracked down on an EdTech company and accused them of having quote unquote careless approach to cybersecurity because they had suffered a data breach that exposed the personal information of a number of students, I think tens of millions even of students back in 2018. So the FTC said that poor password management practices and other unreasonable security practices resulted in a former contractor for this company using credentials to steal not just names and email addresses and passwords of I think around 40 million users, but that there was also sensitive information involved, like information around students' sexual orientations, disabilities, religion, or parental income. And some of that information was later found for sale online. And so this is an example where the FTC is sort of flexing its muscles, saying we released this policy statement. We are very serious about security requirements for kids' data. And it's something that as EdTech vendors, I'm sure everybody on this call has an absolutely flawless security program, but it's never too late to double check it. And it's important to make sure that the security that you're using to protect kids' information collected under COPPA aligns with reasonable security requirements from the FTC. So I just talked for an extremely long time. I hope that you all learned something. I hope this was helpful. I know Miles had asked me to leave a couple of minutes for questions. So I'm happy to do that, happy to open the floor.
Yeah, thank you so much, Sophie, and really wonderful presentation on some very complicated laws. I thought probably easiest if we just go ahead and ask the questions. I'll ask the ones that I see in the chat and then get your responses to them. So we have a question from Anonymous. In the case of an individual teacher accepting click-wrap terms, what is the Department of Education's view on whether that operates to create a school official relationship on the behalf of the school?
Yeah, so what I would say there is that it depends, first and foremost, what is in the click wrap terms. Do you have the appropriate provisions? We talked about when you're a school official, you want to have language in there that says, for example, that you are operating at the direction of and on behalf of the school. Technically, a teacher is able to consent to those terms, but again, Department of Education and FTC encourage acceptance of those and agreement of those to be at the school level. And so as long as you have the appropriate language in that agreement, and to the extent that the EdTech vendor actually fulfills its obligations under FERPA, that is sort of the most important thing. So you can take that and do what you will with that advice.
And looks like we have another question. Are there federal or state level requirements for data security, privacy, confidentiality, etc., with regard to EdTech vendors and FERPA, i.e. a certification or third-party attestation?
So under FERPA and the school official exception, when you function as a school official, you have the same obligations that a school would have with respect to privacy and security, confidentiality, disclosure, use of student information. So requirements that will apply to schools or obligations that apply to schools will also apply to you in that way. There's not a specific third-party attestation for security, for example, that's required under COPPA. There are under state laws, and I know that you all have a session on this later, but certain state laws have security requirements that you would need to meet in the student privacy context. So states have their own student privacy laws that are kind of supplemental to FERPA. So New York, for example, has an obligation that third-party contractors have security programs that are aligned with NIST as one example of that. But as far as specific obligations for security, I think just a reasonable expectation of security under FERPA.
All right. Well, thank you so much, Sophie. That was a real tour de force through, like I said, very complicated laws. And I'm sure everybody here is very thankful for the level of detail that you gave and the level of nuance that you gave as well. I think we are going to head into a break and probably take until, what's this say? I think we're going to take until 11:30 for our break. So feel free to stand up, stretch, get a glass of water, do some jumping jacks. We actually do seem to have another question. Sorry for prematurely jumping to the break. Sophie, if you wouldn't mind answering this question, I think it's a good one. Would COPPA apply to vendors in the finance districts, i.e. accountants, tax preparers, for, I guess, assuming that this is in the context of accountants, tax preparers for school districts?
Yep. So, if a child has their own taxes, they must be a very successful child. I'm jealous of them. So COPPA applies to your online site or service to the extent you directly collect information of children. So, if you have a website where you collect that information about kids, then COPPA would apply. I think it would depend kind of on the specific facts and circumstances of your business, but to the extent you just provide tax services for a school district, for example, I think you would want to look at whether or not you actually collect kids' data directly in that circumstance.
All right. Well, thank you so much, Sophie. like I said, a really wonderful presentation, and I think we're all ready to take a quick break. We'll be beginning again at 11:30 with a panel on proposed federal legislation and state law developments. All right, good morning, everyone. Thank you so much for joining us again as we move on to our first panel discussion for the day. I am very pleased to bring these people to you. They're going to have a really wonderful discussion, I'm sure, but wanted to introduce you to our panelists. So we'll have Sarah Cluck, the Vice President of Education and Children's Policy at the Software and Information Industry Association, and one of our good colleagues and a friend of FPF that you might see pretty often as you come to these types of events. We also have David Saleh, a recent addition to FPF's Youth and Education team. He is my boss, the director of the Youth and Education program here, and he's joining us after recently leaving the State Board of Education at Utah. Wonderful to have the practitioner's perspective in this discussion. And lastly, we have Bailey Sanchez, a good friend of mine, another policy counsel at the Future of Privacy Forum, and an Adam Driver stan. Wanted to get started by posing a question to Sarah. We recently, in this last session, heard a little bit about the policy statement from the FTC about COPPA and its application in the education technology space. Wanted to get a little bit of detail from you, your thoughts on how compliance programs should be thinking about this policy statement and what the next steps might actually look like.
Sure. Well, when I read the policy statement, it is, first of all, it's nothing new. It's a policy statement reiterating what COPPA has long said and what the COPPA FAQs have long said. But it's reiterating from a commissioner level what they believe and what they believe and what they intend to do around COPPA. So I think as companies are looking at it and reading it, it shows what the commission might be focused on in enforcement, things like security, things like data minimization, data retention, and should look at their internal policies to make sure that they are aligned with what their company needs to do and what their company says they do, and aligned with the expectations of their customers.
Now, one thing that we recently saw from the FTC following their policy statement on education technologies and COPPA was this recent decision, or I guess a settlement that came out regarding CHEG.
Mm-hmm.
I wanted to see if you could speak a little bit about that and its relationship to the rule, to the COPPA rule, if it even happens to have one.
Sure. Well, I don't think CHEG collected data from kids under the age of 13. So the COPPA policy statement really didn't have any play there. So the CHEG settlement was more focused on data security and or the lack thereof, and it is now going to require CHEG to do certain things on data security and monitoring to make sure that they're protecting the data of their customers, which are, generally speaking, high school students and post-secondary students. So generally over the age of 13.
Right. And I wanted to ask, do you think that this is an indication of where some of those, I guess, interests lie? Will this likely be the way that future enforcement actions are approached? And do you see COPPA being involved at some point in these types of determinations? And
yeah, I would love a crystal ball into what the FTC is doing. I think what's something to note about CHEG is that CHEG does not sell to schools. They are a direct to consumer product, so the students are paying for that. So you don't have in the settlement the interesting dynamics between COPPA and FERPA and state student privacy laws and the school. Previous discussion was talking about the school official exception and state private, and we'll talk a little bit more about state privacy laws. So that interplay isn't there. I think with what the FTC is going to do, we'll see. We'll see what they do on the COPPA rulemaking. We'll see what they do on the FTC ANPR. We'll see what happens in Congress with anything in the next 2 years. So I think, I don't know. I don't know what's going to happen there, but I think it's just worthwhile to pay attention to making sure that you're doing what you say you do.
Well, and I think, as you've mentioned, that there is some stuff happening at the federal level. In fact, quite a bit. Wanted to add the other panelists into this discussion, but what are some of the things that are going on at that federal level? And then we'll probably move into the states after. Yeah, just starting maybe listing off some of the things that we've been tracking at FPF. David or Bailey, do you happen to want to speak to a little bit of what's going on with, say, the ANPRM for the FTC?
Sure, I can take this one. So in terms of strictly student privacy, there is not a whole lot going on at the federal level, but there's certainly a lot going on that applies to children. And, students aren't children, so presumably these laws will have implications for students as well. So the FTC in, I believe, August announced an advance notice of proposed rulemaking. This would be step one in what would be potentially a 6-year process. So it'll be quite a while until we hear what comes of that. But it is notable for EdTech vendors because, as Sophie talked about in the last panel, Commissioner Rebecca Kelly Slaughter kind of suggested that the COPPA rule review might be on pause. And the attention is really focused on this ANPRM. So the ANPRM is focused on commercial surveillance. That is the FTC's term. So there are 95 questions that they pose, and then 11 of them address children specifically. So that was actually like the largest kind of like subject area that was addressed. So the topics, other areas included notice and consent, automated decision making, and then commercial surveillance. So all of the children's questions were under the heading, to what extent do commercial surveillance practices or lax data security measures harm children, including teenagers? I think this is worth paying attention to because I think it's fair to say that under this current FTC, that, like student monitoring might be considered a commercial surveillance practice. So while it's not strictly like, like in the student space, like FERPA, perhaps, it seems like that is where a lot of the regulatory attention is going, is towards children. I don't know if Sarah has anything to add on that ANPR as well.
Well, I think what's interesting is that the FTC has done some work in the past couple of months on advertising as well, and which is traditionally most EdTech doesn't have what we're thinking about as advertising that we see when we go to just general consumer websites. So I don't actually know if they would do anything in that in what you're calling the student monitoring space, because a lot of that, there's a lot of laws that interplay there. We're talking about laws overseen by the FCC, the Department of Ed. I don't know if that space, if the FTC is ready to play in that space quite yet. I think we'll see, but it'll be interesting to watch.
Now, of course, these are just one of the federal developments that we've seen over the course of this summer. The big one that's on everybody's mind is the American Data Privacy Protection Act. Wanted to see if Bailey or David or Sarah, you could speak a little bit to what is being addressed with children there and what we think its relationship to education technology might be if that were to be passed into law in the lame duck session. And do we even think that that's a possibility?
So I am not the FPFer that has been following ADPPA super close, just because there's been a lot of highs and lows with it and a lot of, I think, some heartbreak. So, but I think the main takeaway here is that under ADPPA, the preservation of FERPA and COPPA would remain unchanged. So there would be no changes to COPPA or FERPA. And I think that's really the main takeaway, because there would be no like amendments to it. And then the bill's section on preemption preserves state laws that govern student privacy. So I think that's really the other main takeaway, is that like this would be a very big deal because it would be the first federal consumer privacy bill. But in terms of its implications for EdTech, I think it would be not as heavy as a lift as other companies. But I know Sarah has also been keeping a very close eye on ADPPA all summer.
Yeah, I think because it does preserve sectoral laws like FERPA. It does not, however, very cleanly address EdTech that is providing services to private schools. So if if you are providing services to private schools or institutions of higher education that are traditionally that need to adhere to FERPA, there's some weird language in ADPPA that says that students don't get to delete stuff, but maintain all of their other rights in ADPPA, which includes a private right of action against private schools, private K-12 schools, and private institutions of higher education. It's a little bit messy. I think they need to clean some of the stuff up. And I think I think a lot of that is just because the committee that has been hearing ADPPA does not have the expertise in schools or education. And it's only being heard in Energy and Commerce in the House side, and the Education and Labor Committee has not, as far as we know, had a say in it.
Well, and I wanted to talk a little bit about the way that children's data more generally is handled in the ADPPA, or ADPA, as some people are calling it, as I'm calling it. The ADPPA deals with children's data as a sensitive data category. There is a knowledge standard attached behind that, but wanted to see if you could speak a little bit to what sensitive data is within the ADPPA and how that might affect some of the practices around children's data, even while we're preserving things like COPPA and FERPA under this new regime, potentially.
Oh boy, do you want me to take that?
Yeah, go ahead.
I did not refresh my memory on sensitive data in ADPA before this call, but it is, there are some special considerations that you need to take when it comes to sensitive data. Those are outlined in the legislation. Again, it's children in the bill is under 13, and they consider minors to be under 17. So there's special considerations for those age groups that need to play.
Yeah, and I think that actually naturally brings us to the next set of federal legislation that's being considered that deals with children. There are currently 4 bills that the Congress has introduced that are being considered that would deal in some way with children's online privacy and safety, specifically as its own sectoral law, rather than being part of the larger ADPA package. Wondered if Bailey, maybe you could speak a little bit about what's in those bills, or what the actual bills are, and then what the progress has been made on them. And then David or Sarah, you could speak a little bit about what's in the bills themselves.
I can certainly do that, but I would just like to let the audience know that Miles actually co-authored a really excellent policy brief on these 4 bills. I can speak to them, but I think we should drop it in the chat because it is, I think, one of the most useful resources on these 4 bills. So there are 4 that are active. I would say 2 are like fairly like salient at this point. There actually was an Axios article, I think yesterday, saying that there are a lot of efforts in Congress to try and get these 2 bills passed during this lame duck session. So the 4 bills are the Kids Privacy Act, the Kids Act, the Kids Online Safety Act, and Children and Teens Online Privacy Protection Act. So definitely a big emphasis on protecting kids' privacy. So 2 of those bills actually would amend COPPA, and then 2 of them are standalone bills. So I'm going to put the other 2 aside for a bit that aren't seeing as much traction. So the 2 that seem to be going the furthest at this point is the Kids Online Safety Act and the Children and Teens Online Privacy Protection Act, or COPPA 2.0. So it is possible that either one or both of those could pass in this lame duck session. So COPPA 2.0 adds a minor requirement. So it adds 13 to 15, and then I believe it has a constructive knowledge standard as well. And then the Kids Online Safety Act, that is the one that is a standalone from COPPA. And so that one is a little bit closer to like a design bill, a bill focused on harms to children. So it covers under 16s, it covers nonprofits and common carriers. It has some parental supervision tools. It has some algorithmic recommendation system safeguards, and it creates a Kids Safety Council. With the Kids Online Safety Act, I don't believe the term commercial is defined. So presumably like nonprofits might be covered by that because the term is not defined at this point. David, I saw you unmuted. Did you have something to add on this?
No, I do not.
Well, and one thing I would also add is that in the definitions that are used in COSA, one of the things that appears to be considered is the use case of education technologies. It's not well fleshed out within that bill, but certainly a consideration that compliance would have to be done under the Kids Online Safety Act in some capacity.
Yep, they use the term educational services. So that could mean anything.
Yeah. Well, and I think one of the key insights too is with all of these bills, with all 4 of these bills, seemingly the main draw of them is to create privacy or online safety protections for children above the age of 13, which certainly would have a pretty major impact on the way that COPPA compliance or compliance programs focused on children work at the current moment. Now, I think that the federal laws, the federal movement has been very interesting, but often obscures some of the most important things to this group of people. What's happening in the states? What requirements are happening with the states, and what requirements are changing for the actual buyer of the products? So I wanted to kick this to Bailey and David to just talk a little bit about the state laws and the states that we've been following over the past year, and what developments we've been seeing, either in the types of legislation that have come forward or what's actually passed.
Yeah, so I can get this started. I think David might have some interesting perspective on this. This kind of ties to COSA. So I mentioned COSA would have like parent monitoring tools. We actually saw in Illinois like a similar requirement that ended up not passing, but there was like kind of a parent dashboard requirement. And the idea behind these is kind of to promote transparency, encourage the parents to be more involved and see what's going on. But like when you take a step back and you think what like a parent dashboard might mean to implement, that could potentially be pretty burdensome. I don't know if David, you had something to add from that practitioner perspective, like what a parent dashboard would be in order to see the entire curriculum, see all of the EdTech tools, see all of the contracts, because that's also something that we've seen a decent bit at the state level is more transparency proposals that would require parents just to kind of see what's going on in the school.
Yeah, I agree with that a lot, Bailey, but that's been a lot more of the kinds of discussions I saw certainly when I worked in Utah. There's a lot of parents who are concerned about what their kids are being taught, what is that content, and wanting more ability to see that. I think though that certainly if you are in the education space, like there's going to be more and more of that question, I think, of not just the transparency to see what is in there that could possibly hit on copyright laws at some point. I know that came up a lot with us, but also what else is the parent able to do with that, and does that conflict with your role as a school official under FERPA? I think one of the big ones that a lot of laws, a lot of the state student privacy laws, I think there might be a gap or a question is certainly regarding deletion rights. So this is a common thing we'll see in consumer privacy laws, is that a parent or the data subject can request that their data be deleted, but like if it's the school who is using it, hopefully you can start to see there'd be a problem if a parent requests to have certain records deleted. And that puts you as an EdTech vendor, I think, in a very weird place that should be very clear that, I think I've seen policies at least that have on EdTech vendor sites that have at least said like, no, you parent, if you need a record deleted, you need to go to the school. But a lot of these laws make it unclear. And I think it really also depends a little because on the type of data that you're collecting. Because in Utah, our law, for example, said that made it very clear that the school is the one that can request that a vendor delete data. But we've had vendors push back on that, saying like, particularly, I think if it's a certification that they don't view as really belonging to the school, that does belong more to the student. Or I think of kind of more creative tools, the Adobes out there where a student is creating some stuff that they might view as something they own far more and wouldn't want the school to delete it. I know I would be very concerned if after I graduated, I logged into my account and wanted to download a whole bunch of stuff only to find out that it had been deleted. And so that's just a simple example of where I think when we start giving parents rights and, the school has certain obligations and rights as a school official, they're supposed to have direct control over that data, where, it's going to put you as a vendor in a weird situation sometimes where if the law isn't super clear, a parent might actually have rights to do things that aren't in the student's best interest. And those are areas we'd like to identify and address and hopefully get laws passed that have better clarity.
Yeah, I would say the Parents' Bill of Rights trend was one of the largest legislative trends that I saw this year. As Miles mentioned earlier, I am a policy counsel on our team. I lead the legislative tracking at the state level, federal level for child and student privacy. So we looked at over 200 bills, and many of them address those like kind of parents' bill of rights, which like on their face, they don't really impact student privacy or EdTech vendors. But when you dig into like those transparency requirements or ability, like we had a couple like camera in the classroom bills as well that didn't pass, they start to be pretty burdensome for EdTech vendors and also really get at student privacy in an indirect way. So kind of like a sub-trend of that we saw was bills introduced regarding surveys and assessments. So, we have the Protection of People Rights Amendment that governs the administration of students, administration to students of surveys and assessments. So a lot of these types of bills that we saw deviated from PPRA in multiple ways, either by regulating the kinds of questions that could be asked beyond like PPRA's 8 categories, or by requiring parent opt-in versus opt-out. A lot of them did not define assessment and could be kind of interpreted in a way that like, any school assessment would have to be posted online on like one of those parent portals. Most of these did not pass, but again, it's a trend that we saw and we think we would continue to see next year. And really the reason why we saw so many of these like kind of like parent bill of rights or like PPRA style bills is because over 40 states have like a student privacy law. So there's really not too many student privacy laws that are introduced each year. One of them we saw was in Pennsylvania, which actually borrowed pretty closely from Utah's bill. I think David is definitely best suited to talk about Utah's law and how Pennsylvania may have borrowed from that. But Pennsylvania is one of the few states that doesn't have a student privacy law at this point. And so that is one state that FPF is keeping a close eye on. So David, I'm going to kick it to you because I think you will talk about Utah much better than I can.
Oh, sure. Well, thank you. Well, and yeah, with that, if you look at certainly the state student privacy laws as they govern EdTech vendors, because some of them directly have provisions that, say things like if you're an EdTech vendor, you can't sell student data, or there's provisions about targeted advertising. But one is that was interesting in Utah, and a couple other states have it, and Pennsylvania borrowed the exact language for Utah is related to contracting, which is where they say that the law basically says that if a school is contracting with a vendor, such as many of you, these kinds of terms have to appear in the contract. And in some of these states, these are extremely prescriptive. I believe Connecticut says like the exact language. New York, you're supposed to include the Parent Bill of Rights. And in the case of Utah, there were some provisions that I feel like are often ones that would appear in your company's privacy policy, but there were a couple that didn't. And one goes back to that deletion clause thing that I was saying that would sometimes be problematic because it said in the Utah law, the contract had to say that at the school's request, the vendor would delete the data. And that's where we'd often run into problems where a company push back and say, we don't think the school is the appropriate party to delete this data because of reasons I already explained. The other one was audit provisions. And I know we're going to have some individuals, I believe one of the later panels, we'll talk a little bit more about like the Student Data Privacy Consortium, which is what we ultimately ended up having to leverage in order to get that provision that our law required into contracts. I feel like this was what a lot of our LEAs ended up spending their privacy time on was contract negotiations. And that was frustrating, I think, for me, because I think that there were other things we could have been looking at. But because our state law said that there has to be a right to audit clause in any contract with a vendor, then that would mean that since that's not typically, I think, a standard term in your existing terms of service or privacy policy, we had to turn every single time a school wanted to use EdTech into a negotiation, which also I think was something that the vendors did not want every single time to turn into a negotiation. And this is where, we'd see some interesting things where some were completely willing. They wanted to be on the right side of privacy law as much as they could. So they said, yes, absolutely, we'll sign this data protection agreement. Others would take the approach of, no, like take a hike. I mean, they maybe said it a little bit nicer, but where it's like, we're a free service. We don't have the bandwidth ourselves to negotiate. And so this is what I thought was interesting because Pennsylvania included the exact same provision. It copied our language exactly. And I think it is the kind of thing that, again, the Student Data Privacy Consortium, I think, has stepped in to address kind of this gap of, of assurance. We put, it's one thing to say in a law, like, you will not do this, and for you to say, yeah, we don't do it. And I think some states, they want to have kind of that next level and be like, no, we need it in a contract. We need it in writing that you aren't actually doing it. And that audit is even kind of the next level on top of that. I should add, because I even asked the senator who, I pushed back against this language quite a bit, actually. In every session, I think, asked if we could tone it down. And he said he viewed it as more kind of like an insurance clause. He did not think that schools would be actively auditing. I pointed out to him that he didn't fund any audits as part of the bill. And he's like, that wasn't the point. Said it's kind of more like fire insurance. If something goes wrong, he wanted that provision in there so that there was a way to look into it. Whether that was the best approach versus, I think you look at New York State, and they had a large data breach with the provider Illuminate, that in that case, I believe the state office, the chief privacy officer of in New York, had authority to be able to investigate. So I would say that is ultimately, though, kind of a trend I could see with other things, is that question of, do we have enough assurance to know that you are doing what you are saying you're doing? And I can see that at all kinds of levels. Obviously, we can even go back to Chegg, which I think, they said we were following reasonable security. The FTC did not have to prod that too hard to be able to determine that, no, that probably was not the case.
Can I go back to or continue on the conversation about deletion rights? I just want to make sure to put a little bit more emphasis on it. So FERPA gives the right for parents and eligible students to have access and amend their education records. The use of data by schools is not just for, and everyone probably on this call knows this, but I want to emphasize it. The use of schools use data to report things like attendance and students that are in their classroom for things like compliance and federal and state funding. So the reason why that data exists is not just for fun. So deleting things, giving the right to delete could impact some of that really important stuff. And while the trend of allowing for deletion rights is there, and we should acknowledge it, companies will need to make sure that what they're doing, what they have in their privacy policies, what they have in their contracts, outlines a specific process for what that means. Will the school contact you? Do you have a direct relationship with the student? Are you going to allow the student to ask to delete stuff? What's going to happen when somebody requests deletion? And I think it's very important to make sure that is in there, especially as we head into more consumer laws, doing a little bit of scope creep into the education space.
Oh, really, really good point. And I wanted to emphasize that if anybody has any questions, please remember to put them in the Q&A. So with all of this discussion and the trends in legislation, the legislation we've been seeing, I did want to ask, is there anything that we saw pass this past year? And if so, what do you think it sort of means for the future of these types of laws?
So we did see one. So I mentioned most states at this point have a student privacy law that regulates either LEAs, SEAs, sometimes also EdTech vendors. So Minnesota had a law that passed this year. So they are the 42nd state, and we are keeping an eye on the others that haven't passed. So the key provisions that apply to EdTech vendors are there's a contract deletion requirement. So I'll just read what it says. It says, unless renewal of the contract is reasonably anticipated within 90 days of the expiration of the contract, A technology provider must destroy or return to the appropriate public educational agency or institution all educational data created, received, or maintained pursuant or incidental to the contract. So I think at one point that was maybe 30 or 60 days. I don't know if you remember, Sarah. I know it was a very short window, and throughout the legislative process this year, there were several amendments to the bill to kind of get it to a place that was workable, because it went into effect, I believe, in August. So it was a pretty short timeline for schools, for vendors to get in compliance with the bill. But other parts of the law that kind of stand out are a bit more typical of like what you'd see in student privacy law. So it prevents EdTech companies from selling, sharing, or disseminating educational data, prevents them from using educational data for any commercial purpose. So includes marketing or advertising. And then another like transparency requirement. So parents and students must be provided with an opportunity to inspect a complete copy of any contract. And then there was another requirement that, like, in my mind, it seemed like a heavy lift for schools, not so much for EdTech vendors. It requires schools to give parents a notice within 30 days of the start of school year, a list of any curriculum testing or assessment technology provider with access to educational data. So maybe in future years, that won't be so burdensome. But again, this passed, I believe, in like May or June, and the school year started in August. So it was a pretty short window to hit that compliance piece.
Yeah, and that specific provision has been causing a lot of confusion in Minnesota. Is it 30 days before, or can it be 30 days after? They don't define what curriculum testing or assessment is. You may get some questions if you have customers in Minnesota on that provision. The school boards group in Minnesota has provided some guidance recently, so hopefully schools all have that. But if you are working with Minnesota on this compliance with this particular bill, I would look to the school boards for some guidance on that if you haven't found it yet.
Well, I'm not seeing any questions in the chat, so I will probably leave you with one last question, and that is, what is your student privacy hot take for things that people should be aware of, things that people should keep in mind for the next year or so in student privacy?
I think we are going to see more children's privacy legislation that may not intend to impact EdTech companies, but will impact EdTech companies because of policymakers not taking the time to understand the educational ecosystem.
That's a very good hot take.
It's a hot take.
Yeah.
My hot take is I wouldn't discount the Chegg decision from the FTC by just being like, oh, well, it wasn't children, or, oh, you know, it was direct to the consumer instead of having the school involved, just simply because of the security things that they looked at. I don't know that we're going to see necessarily legislatively anything more specific. You know, I think most laws that pass just more or less say something like reasonable security methods. But I think at lower levels, you know, at state boards of education I can say that we were talking a lot more about security. And, you know, little things like at some point, someone's going to realize where it's like in the Chegg case, you know, the data were encrypted. Technically, they followed an outdated encryption standard that was basically the same as not being encrypted, but they were encrypted. And at some point, like, I think we are going to be digging deeper, maybe again, not in a law that specifies exactly what this needs to be. But like I think there's going to be much more scrutiny about security, because I think people are extremely worried about that sort of thing when they see data breaches like Illuminate, more so than maybe, like the data deletion stuff that we were talking about, which is an interesting legal question that I think can be frustrating. But I think a lot of the concern is going to come on the security side.
You guys took my top 2 ideas for hot takes. I think David and Sarah are spot on about security. And I think, yes, student privacy is children's privacy at this point. And but to think of something original, so you have a third hot take to share. I think that there's going to be a lot more. Well, we're seeing this trend just generally in privacy and tech policy, but I think it's going to come into play with student privacy more often, but regulation of biometrics and regulation of AI and automated decision making. I think that's definitely something to watch. And again, like the children's privacy issue, whether or not it is intended to also regulate schools and EdTech is yet to be decided. You might unintentionally get swept up in some of these laws.
Well, wonderful. I have the unenviable task of being between you and lunch at this point, so I will forego any further filibustering and release us to lunch. I believe we are going to be coming back at 1:15. So hopefully you have a great lunch, and we'll see you back here as soon as we return. Thank you.
Good afternoon, everyone, or for our West Coast friends, good morning still. Thank you for being here with us and joining us. I'm a new face on your screen, so let me start by introducing myself. I'm Jamie Gorash, and I am a policy counsel at FPF on our youth and education team. And I am really excited to introduce our next panel, so I'm not going to waste any time before doing that. We have today 3 panelists with so many years of experience individually and many more collectively. We have Amy Holliday, who is a digital application and instructional alignment specialist at Lake Washington School District. We have Steve Smith, the Chief Information Officer at Cambridge Public Schools and also the founder of the Student Data Privacy Consortium. And we have Jen Siegel, who is a senior technologist at FPF on our youth and education team, and he also spent many years at Fairfax County Public Schools. So we have a wealth of knowledge on this panel today. Earlier in our last panel, we had David tee up some of the conversation that we'll get more into detail. But for now, let's go ahead and get started. And I want to pose the first question to Amy. We've heard from the Department of Education in multiple different letters or the AGRA letter things that they've released saying that parents and eligible students can't be required to waive FERPA rights or protections as a condition of receiving educational training or services. So I want to know, practically speaking, what does that mean to you from where you sit?
So if the use of a digital platform does not fall already under one of the FERPA exceptions and typically when we see that it requires parental consent, like that is a requirement of moving forward with this platform, it's a lot more difficult for our district to adopt the use of this platform with fidelity. So we would not be able to implement, we have like an adaptive math tool that we use, and with fidelity is kind of the term we use when we introduce it to our community and our students and our teachers. And if that was the case, that it would require a waiver of FERPA rights for some reason, then we would need to be able to provide a similar alternative activity for any students who don't provide parental consent or whoever parents don't provide parental consent, which then what is the value in us adding this tool if only some of our students participate or get to use it? And it's also an equity issue, and students are going to have different experiences based on which tool they use. So for us, it would be much more challenging and unlikely that we would consider the use of the tool.
Yeah, Steve, do you have anything to add on to that one?
Not really. I think Amy captured it well. We We also try to really limit using consent in the school district to use tools that we can't get data privacy agreements for. And when consent is still used by an educator in the classroom, that ask for consent also needs to clearly explain what the alternate teaching method is going to be if they don't consent to that tool. So we're very clear about that.
Yeah, so let's move forward and talk a little bit about what are you looking for when you're reviewing a privacy policy or terms of service from an EdTech vendor? Any of our panelists can take this one.
Amy, why don't you go first? And I want to follow up after you on this one.
Okay, I can dive in. I mean, the first thing I look for, and I will like control F this in the privacy policies, is consent, because I want to see, is that something that is required by the vendor? To provide an example, code.org they require parental consent for the creation of a student account. So that's something that I was able to find really quickly when I was looking at the privacy policy and just to determine how capable we would be of being able to use that tool with our students. There's questions I tend to ask when I see consent as something that is required, and where my brain goes, and again, I have no legal background. I've read a lot of NDPAs. I've read a lot of privacy policies, but I don't have the background that a number of the legal professionals here have. But my assumption I make is the vendor is covering themselves extra diligently for some reason. And why? Why is that necessary? And why would that not allow us to move forward with them? What about their product doesn't fall under the FERPA exceptions?
Thanks. And what I wanted to add was, I've been deeply involved in this particular aspect of my job for about 15 years. And in the beginning, I literally spent years, and I know Jim and I have talked about this, he has too, and Amy, I'm not as familiar, but you may have too, reading and picking apart privacy policies and talking to vendors about them and why they are in there, and very painful. And back then, 15 years ago, there was a lot of education around FERPA like we're doing today, but on an individual basis, trying to explain to vendors what we're asking for, what we're looking for, why we want the data protected and not shared and all these things. And out of that grew the realization that, there is certain expectations that we are asking and looking for in all these privacy policies. Why don't we put them in our own document and get vendors to agree to it? And that was kind of the impetus for a data privacy agreement that encapsulated basically everything we were looking for in a privacy policy to ensure that the vendors are adhering to those requirements, and really by using those, and now it's obviously evolved over the last 12 years into the consortium and the National Data Privacy Agreement model of trying it. Almost not eliminates, but it certainly reduces the burden of having to read privacy policies because we've shifted everything away from that policy into this one document. Terms of service might be a little different depending on more purchasing terms and indemnification and warranties that might go against the local policy. But strictly around privacy, I do much less reading of privacy policies when data privacy agreements are used.
Couple things to add on to that one, and my context is, having for 19 years in the school, I spent a lot of time, like Steve and Amy, reading privacy policies, but I also spent a good deal of time doing the technical texting, the packet capture. So one of the things that I look for is how well does the language in the privacy policy and the terms of service reflect what the actual behavior that I'm seeing in the application is. I kind of like it to data protection agreements. Reading privacy policies is like hiring a real estate lawyer when you buy a house, and looking at the application and doing that kind of testing is like hiring a home inspector. They're both important. They both do very different things. And I look for areas where they may not line up. One of the things that I will do whenever I get a new privacy policy is I'll take 3 sentences at random and put them in quotes and search for them in a search engine. A lot of what I saw for many years was boilerplate language, and that would give me a good idea of whether or not the terms of service really reflected what the application was doing. I'll look for language around consent, but also languages around under 13. I will also search for words like school official. I think it's an important clarification, just because there's so much to unpack from what Sophie said this morning. School official is a designation that the school or district defines in their annual notice. So it is not a universal global definition, that there is one definition of who is a school official. So the school, as part of direct control, is responsible for defining who is a school official and who can designate a school official. It is very uncommon, at least in my experience, and please chime in, Amy and Steve. Teachers, individual staff members don't have the authority to contract, even if it's for $0. School staff don't have the authority to bind a district. And the guidance from Department of Ed and the FTC is that this be handled at the district level. I suspect for the EdTech companies on the call, if I were when we start talking about data protection agreements, I think you would probably view having that data protection agreement signed by the summer intern in the marketing department very different than being signed by the chief privacy officer. Those folks have very different abilities to bind a company, and the same is true in the schools. On the Agra letter, I think there was some boilerplate language in there that really was kind of at the center of things that's worth looking at.
Thanks, everyone. And we will get into those DPAs, I promise. But before we get there, I want to talk for a little bit about vetting apps and what that process looks like. So I'll open that up to anyone on the panel. And I'll also highlight a specific question within that is that we know that, with some EdTech products, you are seeing vendors that offer products that are free for schools, but have paid or, similar additional services for families and parents. So can you also, bring up what that raises for you when you're vetting different vendors?
I think for me, as having spent a lot of years on the technical side of vetting, I would look to get a really good understanding of what the data flow was, kind of starting from the account creation process. Was this something that accounts were created centrally? Was it something that teachers created accounts? Was it something that individual students, parents created accounts, say for like a classroom code or a login code? So getting an understanding of that, looking at understanding what the third-party data connections were, and hopefully seeing that listed in the privacy policy, looking at how authentication was handled, those sorts of things.
I'm curious about the question about parents having to pay for similar additional service. I've seen it before where it's free for schools, but then if you're homeschooling, you may need to, there's like a different process involved. But do you have an example of a tool? Because I don't think any of those have hit my worldview yet.
Yeah, I want to let Jim take this because Jim is very well versed in this.
So I think I would prefer to stick with examples that are in the public sphere. So I think one of the more common ones is probably ABC Mouse, which is a product that is offered free to schools, but also a product that is paid for parents. Certainly, I've also, and how data is handled, is it compartmentalized in terms of data that is under the direct control of the school versus data that a parent may enter that's kind of in the purview of the home? I think the other design pattern or business model that I've seen in this area is where the product is free to schools, but there is a premium option for parents to either provide different services or kind of premium features. And that has a kind of a different set of equities beyond just data privacy and control. It certainly has equity issues that schools need to think about. In the freemium space, this is really kind of the slippery slope because there's very little friction for things like teacher signup. The other area in vetting that I look for is what I call privacy as a premium. I have regularly seen applications where certain security features, certain single sign-on or integration features, or privacy by default features were not available in a free product. So for example, student-generated content was not available to be made private in a free version of the product. It could only be made free and not searchable in the paid version. So I would deem the free version something we could not use under the school official exception.
Yeah, those are all great points. It's hard when you're going third after Amy and Jim to add anything to the conversation, but I was really, the first thing that came to mind for me was the equity issue. And, you know, using a tool in the schools that offers additional services for pay outside raises all kinds of equity issues in our community. And, you know, it just wouldn't be something that we would do. If we felt like those services were really valuable, and we would buy them for all of them. You know, we wouldn't make it optional for others. And of course, the whole idea of segmenting data that Jim brought up does come up fairly often with products that do offer personal accounts, perhaps, you know, versus a school account for the students. And are they treating that data separately? And how are they transferring it between the two? And does the vendor consider the rules of the NDPA that they signed applicable to that data once there's another personal account? And there are some applications that don't make a distinction between a personal and a school account, yet they're providing two different levels of service. It just gets very messy when you don't have a strictly school account.
Yeah, and I want to let everyone have the chance to say something about vetting a little bit more generally speaking. You know, if you have anything else to add on that, what you're looking for.
Well, so, and I know we are specifically talking about privacy here, but I just want to add, when we vet an app in a school district, you know, an educator puts in a request to use an app, there is a process that includes the curriculum departments and technical services, and privacy is actually just probably the last step of that vetting process. So there is a much bigger vetting process before an app is actually approved within a district. And the other point I want to bring out is not so much, I haven't seen it as much lately, but the practices sometimes of providers that are going directly to teachers as opposed to the school administration to kind of get their foot in the door and get an application, you know, being used in a few classrooms and adopted, then all of a sudden, you know, it hasn't properly been vetted because a teacher has started to use it. I mean, part of that is upon the district to put in, you know, good practices and awareness with your educators to, you know, ensure apps are vetted. But the practice of some vendors to go directly to educators, knowing they're kind of circumventing an official vetting process, is discouraged.
And so connected to that, and Amy, I don't want to cut you off, so I'll let you speak to that right after. But, you know, if a vendor does find that they're getting a lot of outreach from other members within the school community, I'm wondering if you have any tips that you want to share for how they should be handling that.
I can address that one. In relation to vetting, my title is long, and like I stumble over it every time I say it because it's a made up four-lettered or four-word term. But what it essentially means for my district is that every single request for use of a new digital tool goes through me, and then I review all of the digital tools currently in use to ensure that there's no changes to privacy policies, et cetera. It's become a really large job as our library has grown. But when it comes to multiple individuals from the same school district reaching out to a vendor, good on the vendor for identifying if that's happening. That's great. In our vetting process, we involve, like when departments and or teachers are requesting the use of a digital tool, part of that process that we're asking for them for more information, the department that's requesting is, do you have a vendor contact? Have you already reached out to them? So typically we're already aware if contact has been made, and then we'll kind of like be a part of that stream. But if a vendor is identifying this and it hasn't been communicated yet to the school district or whoever that, hey, more than one of you are reaching out to us about this, I would say reaching out to the different folks at the same district and just saying, who is the primary contact that I should be using for the district? And also if it's different buildings, that could be happening too, where like each building is trying to create a building license, like, hey, would you like to hear about the possibility of a district license? Because often that's going to be a savings if we want to go district wide. And it's atypical for us to adopt things for specific buildings because of the equity issue that proposes.
Yeah, thank you for that. So let's move on to the contracting part. This is the real meat of the conversation. And I would like, any of our speakers to just sort of talk more broadly. What are you looking for when you're reviewing a DPA? What clauses are you finding are drawing the most commentary or changes from vendors? And, how is this impacting your work? How do you go about negotiating that?
Sure, I'll jump in there first. I'm not sure just how much the group has heard about the consortium and the National Data Privacy Agreement model that the consortium produced, but maybe just a short history about it. The consortium was formed about 7 or 8 years ago with the idea of bringing districts and vendors together to address some of these operational privacy issues. And one of the first projects that we addressed was trying to come up with common data privacy agreements or common clauses that make sense. And it was really just a matter of bringing folks together to talk through the FERPA and local jurisdictional requirements and again, come to agreement on those clauses. It wasn't, extremely difficult. It's more a mediation process, right? And so over the years, the consortium started out with multiple DPAs in different states across the country. And then about 3 years ago, started working on a national data privacy agreement because people were realizing there were so many commonalities between the states. And about 2 years ago, launched a national data privacy agreement, which has a core set of standard clauses in it that are really the lowest bar, the FERPA requirements. And I did listen in a little bit earlier, a lot of talk about the school official exception and how that is used by school districts. So the DPA starts right out by clearly establishing the vendor as a school official for the very specific purpose of that service that they're providing, and then goes on to talk about the kind of controls or expectations around the data, how it can and can't be used. Again, for the most part, it's all, common sense and meeting the low bar of FERPA. But having said that, there always are some conversations or pushback or concerns about specific clauses that may conflict with a service, or it could just be wording and things like that. So as far as, clauses that I see lately as the most kind of, so for practice, for those vendors that aren't familiar, the consortium members typically will just send out this national data privacy agreement as it is and ask vendors to sign them. And probably 85% are signing them, 90% as is, and then we occasionally get red line pushbacks. And this is somewhat of a, I'm not directly involved, they don't come directly to me, but what I've seen, I think the areas that we see the most kind of edits in or pushback in are the audit section of the DPA that talks about school control and ability to go in and do audits of a vendor around privacy. And also there's still a lot of discussion around the use of de-identified data, what is allowable, what vendors want to do. To me, those are the areas I think of the NDPA that get the most red line edits today.
Amy, did you want to add anything in there?
Oh, sure. I have commentary on the exhibits, but related specifically to the clauses, the pushback that we get the most is in relation to timing. So the DPA usually very clearly spells out the number of days that something needs to happen on the part of the vendor if there is a data breach, or if there is some kind of change or some kind of contact that needs to happen, or an action on their part. And we've gotten really familiar with as soon as reasonably practicable. So usually what that just involves a conversation, so we can kind of understand why the number of days would not be appropriate. And typically we've been satisfied with the responses.
Jim, is there anything else that you want to highlight, other clauses to consider?
I think that covers a lot of the clauses. The data breach one, certainly in Virginia, there was recently a requirement for a data breach law that cut it down to 24 hours for notifying the state. So that's certainly very much on my radar. And that applies to the schools. So the schools need to be able to put that into contracts for the vendors. Like Amy, I have a few things to highlight on the exhibit. So I'll let you take it first, Amy.
Are we okay launching into the exhibits? I do remember the question specifically said clauses.
Yes, but exhibits are fair game.
Okay. I have two main ones. The first thing that I always go through is I look at Exhibit B, because Exhibit B, I feel like sometimes it can be perceived as like a free-for-all, like a buffet of student data. And there are some vendors that will check things off. And then when I reach out and say like, hey, can you help me understand why you need like parent contact information for this tool when the DPA indicates that you will not be directly contacting parents, then they're like, oh yeah, we don't actually need that. So I always look to ensure that the data in Exhibit B relates specifically to the use of the tool and the vendor's ability to provide that service. And then the other exhibit that will come up, I think, often is Exhibit H, mainly because our district has added additional amendments there or additional changes there. And I want to check and see if one, they've agreed to those, and two, if they have proposed additional changes within Exhibit H, because that's the purpose of that exhibit, to make any changes to the wording of the document itself.
So just to clarify, Exhibit H is the state-specific agreement, correct? And then Exhibit B, do you have, is maybe Steve here can share with, just in case anyone doesn't know.
In our agreement, H is the district specific and G is the state specific. And then B is the data that's being requested.
Okay. Great. So do you want to talk a little bit about, what from the vendor side, what can they do to make the process of negotiating run more smoothly and connected, if there is an impasse on some of the more specific clauses that are changed, what is your response to that? How do you then move forward?
Well, the quickest way to make it run smoothly is just to sign the DPAs.
I had a feeling that would be the answer.
I don't think that was the answer you were looking for.
The path of least resistance.
Right. But yeah, when there is a need for a conversation about a particular clause, I think it's important to explain why they're asking for those changes. Just getting a red line back with alternate proposed language can be interpreted the wrong way without the context of why they're asking for it. Typically, you can get down to the reason, and some of the edits, there is a portion of edits that is wordsmithing, that you just feel like it sounds better, it maybe makes the intent a little clearer, and those are perfectly fine. Some of them have to do with the service themselves, the providers that can't meet the requirements, and they're trying to figure out a way to, fit into the requirements. So those need some further conversation to see if there is a way to do it. And then there are others that just can't meet the requirements for one reason or another. And you do occasionally meet an impasse, and we find another tool. I mean, like I mentioned earlier, parental consent is an option of last resort that we kind of discourage, and it would only be used if we're sure there's no, really bad use of the data, and they just can't sign the DPA for one reason or another. But a use of the data that is clearly articulated to the parents, this is what's going to happen, the potential. So here's a number of tools that fall into that consent area that we still allow today. Is a whole other category that is typically developed out of higher education institutions. They start out as a research project or something, like Scratch, right? Very widely used tool built at MIT. They still today cannot sign a DPA because of how the data is used for research and shared on the back end. That is one that we do allow parental consent, and parents are well informed of how that might be used. And Scratch is working on an educational version, so they can sign the DPAs, but that's an example. But when you do get to a complete impasse that, you know, for one reason or another, it's just not usable, we just look for an alternative and do not approve it in the district.
Thank you. Jim, do you want to talk a little bit about COPPA and DPAs and things to be thinking about when evaluating?
Well, I think the COPPA context, I think, really falls into the terms of service area, just because I think it's important to clarify, and the regulations does not do a good job with this, is there are really two contexts where the school is acting as the parent's agent and they are providing consent. And then there's another use case, which is where the school is acting as an intermediary. And unfortunately, because it's not in the regulation of the statutes, just in the frequently asked questions, this language is all muddied together. And an intermediary is often, this is one of my big red flags when I read terms of service, is I look for language where the vendor is saying, the school is solely responsible for compliance with COPPA, which the Federal Trade Commission has said is not acceptable. Or I look for language where the vendor is saying the school is responsible for getting parental consent, and sometimes they'll provide an example of a parent permission. That to me is a big red flag that the product is not able to be used under the school official exception and COPPA's exception, where the school is providing consent on behalf of the parent, and it's only being used for educational purposes. The other big thing is, if you think about it, having the school collect the permission slip and hold on to it where it's outside of the school's ability to consent breaks the vendor's responsibilities for COPPA. If it's being used outside that consent, the vendor has to allow the parent to inspect the record and prevent future collection. So that means that the vendor can't meet their obligations under COPPA, which is why that particular take on the school being the intermediary, if they're holding on to it, isn't going to work. So I look for, if I see that language, my next question is, okay, vendor, where would you like me to send those permission slips? Because that's the next step. Box those things up and send them off, because the schools can only act as the parent's agent.
Thanks, Jim. So I understand we have a new version of the NDPA coming out at some point soon. I know it's actively being worked on right now, but because we have such a celebrity in our midst, Steve, are you able to give us a little preview of what to expect as far as the changes?
Oh, yeah, and I don't take all the credit. Jim's here too. He's helping with the process. So, and just a little bit about the process. So the consortium started working on the next version of the NDPA about 6 or 8 months ago. And in order to avoid some of the not very organized meetings when we created the first NDPA, we put more structure to this. And we asked district membership to come up with suggested edits, and then we asked the provider or vendor members of the consortium to come up with proposed edits. And that process took about 6 months. So now we are bringing the two together with just representatives from those groups. And Jim and I are actually moderating that process or mediating it to bring together. And really, I think the changes or suggestions fall into 3 buckets, and they're all good, right? We're really, gradually improving something to make it work smoother, which has already been very valuable. So it's incremental improvements to this instrument. The first bucket is structural, just changing the structure of the document. There's a lot of proposals around that just to make it flow better and be easier to use. The second I would categorize as just like clarifying some of the intent, through changes in language and sentence structure. And then the last is actual substantive changes in the meanings, and there's much less of that than there is anything else. So overall, it's just going to make the NDPA work that much better and less of those red lines, and really just bringing everyone together even closer. So.
And I think maybe it's a good cop, bad cop if Steve gets to moderate and I get to mediate. I think the two substantive things that I'm looking for in particular are kind of clarifying the language around when the vendor has to disclose data to law enforcement in particular, or for example, in response to a subpoena, or in response to a health and safety emergency, which are two of the FERPA exceptions. And I think it's really important that the school or the district be very clear when and if they are designating the vendor to have that very specific decision authority. But the second part of that is, if that is the decision that the school wants to empower the vendor to do that, there still needs to be language so that the school can fulfill their requirements. Schools, when those two exceptions for disclosure are triggered, the school has a requirement to record that disclosure was made. And unless there's language or a process for the vendor to communicate that disclosure was made back to the school can't fulfill their responsibility. So those are two things that I think I'm looking forward to enhancing in this version.
Great, thank you so much. So let's move into just a quick discussion about enforcement and monitoring. Can you talk a little bit, any of our panelists, can you talk about, what happens when vendors make changes to their product after you sign an agreement?
That's a good question, Jamie. So I think we would hope that a couple things. If the changes are being made to the product, and they've already signed an agreement, hopefully those changes are within the expectations of the agreement, not violating it. Hopefully any improvements moving forward are going to provide more protections rather than less or risks to the products. But if, on the other hand, they've decided to make a change that they can no longer abide by the NDPA, I think I was looking through the DPA, and I don't know if there's any language in there that states that they have to notify us that they are now violating the DPA or have made changes to their product. But you would hope that they would notify districts that they've made this change to the product, and it may come in conflict with some of the requirements of the DPA.
My assumption would be that it would also have to be replicated in a change to the privacy policy, and we always get those notifications. Whether or not people read them, it's another story. And Steve, I wonder, because you were mentioning whether or not, I don't think there's like an action item associated to it, but in Article 4 under duties of provider, there is that component that says the provider shall comply with all applicable federal, state, and local laws, rules, and regulations. All as may it be amended from time to time, which allows the state laws to be amended, but not necessarily what they've agreed to. But I don't know what the action would be. I have experienced improvements made that make tools even more safe for us to use with students. We've been able to not sign before based on the data requested, and then they've made changes to the tools that have allowed us to sign. I've never had the opposite happen.
Right.
I think from my experience, just the virtue of the model of this being a model contract and having, was it Steve, 32 states? I don't remember off the top of my head, having so many states and districts familiar with the model language and having leads in the states and having an advisory board that this trickles up to. I can think of off the top of my head 2 or 3 specific examples on the advisory board over the years where an issue has bubbled up to the advisory board level, and we've compared notes across what the experiences are across districts. So I think just the nature of the structure itself helps that kind of oversight.
Great, thank you so much. So I am nearing the end of my question. So I want to encourage everyone who is attending to feel free to drop your own questions in the chat. We have so much expertise here, so please take advantage of that. Another question that I want to pose to really everyone on the panel is, what do you wish vendors better understood about your obligations, specifically under FERPA, but also just otherwise that go along with your job?
Well, this might sound a little corny, but I was thinking, if a good way to look at it is think about for the vendors out there that do have children, how would they protect their children online? How would they look at their child's data when the kids are playing around with apps and things? And that's really how I feel when we are selecting apps to use for 7,000 kids to use. We want to ensure that they're being protected and the data is not being misused or leaking out or anything like that. So, thinking of the school districts that you're dealing with as being that kind of protective of the kids, and all for good reason, right? It's not like it's us against vendors. We're all just trying to create this safe online environment, just like we do a safe physical environment, so that when these kids turn 18, become adults, and start their own adult life online, there isn't anything that any accumulation of their data by bad actors that's going to affect them in life. So yeah, thanks.
I don't know if this was included in my intro, but I work in the Lake Washington School District, and this segues really well off of what Steve said, but my district is in Redmond, Washington. So we have, I would say like 75% of our parent base, that might be an exaggeration, but a very high percentage are parents that either work at Microsoft, Amazon, Google. Oh, there's others out there, but those are kind of the big hubs that we have here, Facebook or now Meta. And what's very interesting is in the past, our district was pretty locked down and like very intent upon locking down WASPAs before the NDPA. So we were working on privacy agreements. This is my 5th year in this position. And our feedback was very frequently from vendors like, well, so-and-so district uses it, so why can't you use our tool? Or so-and-so, and it was a lot of comparisons where I really felt like the bad guy. And teachers too in our district would say, I used to use this tool in this district, like, why is it not allowed in our district? Things are changing in Washington State. I'm no longer this lone wolf that feels very sad and like I'm telling everyone no. Because one, the SDPC has been doing this incredible work and bringing on tons of vendors as well to understand like what these agreements are for and why they're important. But also the district outreach has been really great. But I would say that one of the reasons that we've been so careful so early was because we had parents that would go into, we had a parent that showed us how they could hack into one of our remote monitoring tools. And when you have that kind of feedback that's so present in your community, it makes sense that we're going to be a little extra careful. And so I think the phrase I put down in response to this question is we're not choosing to be difficult, and we have the same goal. We're trying to provide a solid, safe education for students, and we need the help of a lot of these vendors to be able to do that in the most efficient and effective way at times. So that's kind of my number one. My second thing is, if I could have vendors help me in one way, it would be only request the data that is absolutely necessary to provide the service. And I don't think I need to provide any examples of why that's important, but that's critical to us as well.
Thank you. That's really helpful. Jim, we have some questions coming up in the chat that I think are a follow-up to a conversation you teed up before. So can I look to you
and
to
I feel
answer?
like in trying to clarify some of the conversation, some of the points from this morning, I feel like I've opened a can of worms, but this is one of the most problematic things. And it really exposes just a fundamental problem that there is a lack of alignment between FERPA and COPPA. We've been trying to deal with this for years. There was a 2017 panel I was on. Steve, I don't know if you were on that, with Department of Ed and the FTC. No guidance came out of that. There were 11 questions in the comments for COPPA back in 2019 that dealt with the interaction in EdTech. We have not seen anything like that. But at the simplest point, there are educational applications that fall under where we could use them in schools under the school official exception. And if it's not using data for any commercial purpose, just providing an educational service, then the school, it may, not must, may provide consent on behalf of the parent. Typically, when the vendor has to directly get consent from the parent and can't rely on the school, that's going to align directly with the school's requirement to have to get consent. I know I can't think of an example, the difference between ages aside, I can't think of an example where there would be a requirement for the school to have to get consent and it wouldn't trigger the responsibility of the vendor. So we both have the same challenges in terms of getting consent. We have to get consent, and so does the vendor. And typically at the moment, there's no good guidance for how that can be aligned. They would be separate processes. So in creating the student's account, it would trigger, we would collect the FERPA consent. It would trigger the requirement for the vendor to get consent under COPPA. The other possibility is that there could be a system that would address the gap in what most vendor privacy policies deal with in terms of this language, which basically makes the school an intermediary in collecting the permission slip. But I think just any basic understanding of the definition of intermediary is that it goes somewhere. We would, if the post office was an intermediary, the way most privacy policies describe it, they would never deliver the mail. They would just hold on to it. So I think there would have to be a mechanism for the school if the term said the school collects the COPPA consent, it would have to go to the vendor. In particular, think about how frequently students change schools. This creates an enormous number of abandoned accounts and abandoned COPPA rights. We can be the parent agent, but if the parent needs to reassert that if the child has left the district.
Thanks, Jim. So we are now at time. I think there is one more question in the chat. We can also potentially take that one offline. Please feel free to reach out directly to us at FPF. And so I want to just say thank you to the panelists today, Amy, Steve, Jim. This was really wonderful and informative. And our break will be done at 2:15 Eastern. So please join us again at that time.
All right, welcome back, everyone. We are coming towards the end of our day, and we're going to be mixing things up a little bit with 3 quick lightning rounds. So these are topics meant to give a taste of future potential webinars in more detail. So I'm going to be starting off talking about privacy and security in EdTech applications and digging into a recent EdTech report on privacy and security. I'll be followed up by my colleague, Bailey Sanchez, talking about EdTech compliance under comprehensive state privacy laws. And we'll be closing out the day with Lauren Merck talking about EdTech, privacy, and emerging technologies. So with that, we'll be starting with a little bit of technology. And I apologize in advance for the lightning aspect of this lightning talk. This is a talk that I normally give each of these 2 topics in about an hour each. So it is meant to give a high-level overview. And I know several of you that are with us today are on the developer side or on the security side. So this is meant as a high-level overview. Just to put the day in context and close out with some security. So we talked a lot about privacy practices related to collection, use, sharing, deletion of educational data. Very much related to the idea of security, preventing unauthorized access, preserving confidentiality, integrity, and availability of data, that CIA triangle. They are very closely related, but they're not interdependent to the extent of you can have one, but not another. So if a bank is using your information to provide services, privacy and security are maintained. If a bank gets hit by a denial of service attack, privacy is still maintained. but the availability aspect of security is compromised. And something like ransomware with exfiltration, a data breach, is a compromise of both. And when I think about risk, which was a lot of what I did for many, many years at my large district, I thought about risk in two ways, in three ways. I thought about the risk of being out of compliance. Is this in alignment with regulation, with policy? And most importantly, especially with security, thinking about the risk of actual harm, of identity theft, of embarrassment, of loss of opportunity, of data deletion, destruction. And then lastly, and something that is always on the mind of those of us coming from the public sector side, is the public perception risk, the lack of trust. Having worked in Fairfax County, this was the "we don't want to be on the front page of the Washington Post" rule. And it's something that I think about a lot in terms of managing risk and perception, creating that culture of security and privacy. There were a number of conversations that we had earlier today about state laws and student privacy, and they touch a lot on security. There is no requirement at the federal level in FERPA or COPPA for specific standards. There's a lot of conversation about what reasonable security is, which is more of a rear view mirror look at based on what decisions have come out of the Federal Trade Commission related to security. But what we're seeing since 2014 is that several states have enacted laws that have much stronger security requirements. For example, some common themes: requirements for having a security plan, and depending on the state, these could be requirements that apply to the district, apply to the state educational agency, and in the case of several states, are requirements that apply to the EdTech vendor. For example, California, New York in particular has some very strong requirements in terms of having a security plan. There are several states that have requirements for both districts and vendors to adopt specific security standards. And unfortunately, there is no universal agreement on security standards. And folks like Steve and myself are actively having conversations around, are there security standards that could be of common agreement or a crosswalk? But for example, New York requires NIST cybersecurity framework, whereas New Hampshire and Texas have a different security standard. They have the NIST 171 standard. What I like about New Hampshire is that they have an equivalency, so they'll accept a vendor or a district if they are supporting one of several equivalent standards. And Illinois' COPPA law uses the CIS 18 controls. Several states have some very stringent timeline requirements for data breach notifications. These are typically most often for the school to comply to, which is why they need to be in the contract so that the vendor can notify them so the school can meet their requirements. I mentioned earlier that Virginia, just as of July of this year, has a 24-hour deadline to notify the state security fusion centers. One of the things that's been on my radar, coming from a large district, I spent a lot of time looking at higher education, which had something called the Higher Education Vendor Assessment Toolkit, which is a standardized questionnaire. I've always wanted something like this in K-12, and I'm very optimistic. COSIN, the professional group in K-12 for technologists, is in the process of developing a K-12 specific version of the light version of the HECBAT that we'll see, I believe, probably sometime in the spring. So that's really something I think that helps standardize a conversation around the questions that schools ask vendors and what the expectations are for creating a standard for reasonable security. My colleagues mentioned some recent actions by the Federal Trade Commission that really tie into EdTech and security. The May policy statement from the FTC focused on three things: prohibition against mandatory collection, so not requiring more data than is needed, so data minimization. Particularly, I would always look at this for things like, is it asking for information like social security number or particularly free and reduced lunch information, which almost has some very strict requirements. How that data is being used, is it being used for purposes outside of what the legitimate educational purpose is? How long it's being retained. If you look at some of the most recent data breaches through ransomware, for example, LA, New York, one of the things that really jump out is how long historically that data goes back. Some of the data breach data goes back 5, 10, 15 years. It's very unlikely that a school would need the data to be retained that long. One of the things I like about the FCPC agreement is there's a data deletion request, but those are typically when the contract ends. Some progressive schools like Montgomery County here in Maryland have an annual data deletion day, where for a certain set of products, they request that the vendor delete that annual data. This aligns a lot with the retention schedules that schools have. This becomes a really important issue for vendors. I'm thinking in the content filtering space, where that data may be problematic to have a long tail of a log record on student searches. And then lastly, security requirements, really emphasizing that the FTC is not looking just at data breaches, but generally all security practices. I think in terms of wanting to get some clarity around what are good security practices, what are reasonable security practices, I look at things like recent FCC settlements. The one with PEG most recently focused on security, but also I think probably one of the more detailed and actionable ones is the FTC settlement with Zoom that happened about 18 months ago. Really focused heavily on the requirements for having a written information security plan, and focus on some really quantifiable bullet points in terms of requiring encryption, tokenization, monitoring and testing, having independent auditing, having a vulnerability management program. These are really good practices, and I spent many years looking, writing requirements for RFPs and reviewing EdTech vendors. These were all things that I would look for when I was acquiring EdTech at the enterprise level. And I think really useful keys for what is the bar in education for reasonable security. And I think the security plan is a key part of that. I spent many years testing EdTech products. And one of the things that came out was not just thinking about the design, the product management, the design of the application, but thinking about security across the whole life cycle of the product. And it starts with design. And I would look for many of the basic things that I'm sure are common conversations, but I think it's useful to talk through them. Looking at things like password length, looking at lockouts. There was nothing more challenging than trying and outsmart a 7th grader with a lot of free time on their hands in terms of password guessing or trying to break into a classmate's account to try and embarrass them. So thinking about limits on lockouts, thinking about reset questions that might be common for adults tend to be the kind of things that occur in childhood. So, who was your first grade teacher? Or what, where street do you live on? Those types of things either don't apply to under 18 or they're known by, other students in the class. So thinking about useful reset questions. Doing privacy challenges that could get brought up in the testing and bug fix stage. In particular, in my organization, we had one particular security challenge that the vendor viewed as a feature, a convenience where a teacher could reset the password of any student that was enrolled in their class. Hugely important because time is an incredibly valuable commodity. A teacher can't just leave the class to get technical support. But when combined with another feature that lets a teacher enroll anyone in the system in their class, having a student get access to that teacher's password. In my particular district, the student enrolled the superintendent and reset the superintendent's password, and that was one of the times that we ended up on in the Washington Post. And also just thinking beyond the application itself, thinking about third-party libraries and APIs. When I would do testing, one of the things that I would test would be to look at the URL for an API call, pop that out and put it in an anonymous browser and see if it could still pull up data without the associated authentication. So those are really key things where I would see challenges in EdTech. Testing data is another challenge in terms of either masking data or using non-live data. We saw some examples here in the DC area where a testing server was had live student data and it was left exposed. Just general good security practices like requiring support staff to use solid two-factor authentication. And I think one of the most common things that comes up as a trend in data breaches are things like exposed, unprotected Amazon storage buckets. So those are some of the things in terms of thinking about security and privacy throughout the whole software lifecycle. And lastly, thinking about the carbon-based elements, the human elements, the non-technical aspects. The majority of security issues tend to be people. This is one that I always think about from Bill Fitzgerald, prominent EdTech security researcher and good colleague, had come across a help forum where an EdTech employee had answered a question in the help forum and included personally identifiable information. So thinking about not just the technical aspects of security, but thinking about how to train people, both in terms of good security, but in terms of how to be responsible in terms of appropriate sharing of information. Some of the things that have come up over the years as general good practices, looking at encryption, just inventorying and regular patching of systems, and having a solid bug reporting system for security researchers or districts to be able to contact you when there is an issue or a concern. And there's some very good resources for doing security testing. This is an example that I worked on several years ago with Common Sense Media in terms of a basic toolkit for testing. So that is a very quick highlight of security. The other thing that I want to leave you with today is how advocates, how the public can look at EdTech products in terms of privacy and security. There was one particular report that got a lot of attention over the summer from Human Rights Watch, a very well-respected organization. The report was called "How Dare They Peep Into My Private Life?" And it had some rather damning, rather sensitive findings in terms of their conclusions were that 89% of the applications appeared to engage in risky activity. I wanted to comment on this because this was very much the kind of testing that I would do for 19 years at Fairfax. And I wanted to talk a little about my take on the report and where some of the, what I think some of the gaps in the methodology are, but also really practically how to think about this in terms of being transparent as an EdTech vendor and providing good information in your privacy policies, in your security centers. The report has some very solid recommendations. Many of them align with what we see in recent laws, such as a ban on behavioral advertising in written contracts. It looked at 149 applications, several of them US applications. But what I really wanted to highlight was really two big challenges. One is that for the most part, they looked at what's called static analysis of the code. They looked at the code itself and they ran some tools that said, these are the third-party libraries that are included. And from that, they made some conclusions about what data was shared. Now, as a technologist, this is the kind of testing I would do all the time in Fairfax. And it's a, if you see smoke, check for fire situation. What they did not do was they did not do the dynamic testing. They did not actually use the application to see if the presence of a software library actually meant that data was being shared. So I think this translates for me in having really good, solid communication and a privacy policy on what data is being shared, what third parties are being used, and what is the reason for those third parties to be used. The report did not make a lot of distinction between data sharing with a particular company for reporting data for analytics or crash detection versus the capability of that same third-party provider being able to serve ads or detect locations. So disclosing how you're using the data is and sharing it with a third party is really important to kind of really head off some of this type of conversation. That was for mobile applications. They also looked at web applications. They used a tool from the markup called Blacklight. And I think the gaps there were that tool didn't and can't test behind a login, which is really how most EdTech tools are being used. And I think what jumped out at me in the report was that the testing was not particularly relevant. They looked at corporate websites, not the actual application that was being used. So I have some example URLs here. And for me, this is kind of like if someone was reporting on the security and privacy of my doctor's, informational website versus my doctor's patient portal. So I think being very clear on the privacy policies, if you have a different privacy policy for your corporate website versus your application website, those are tremendously helpful. And for developers, one of the things that's a very common design pattern is having a link on the home, the main website that links and lets you log into the actual application. I would love to see having that login button know that a user had come in from there and maybe clear any ad tracking cookies when that user clicks through to actually use the EdTech application. There are some really good examples of how schools have responded, and I will include this in the slides. There were some very good, thoughtful examples of how the vendor community responded to this. This is becoming more and more common of a advocacy approach to combine advocacy and semi-technical or pseudo-technical research. So I want to leave you with those thoughts today. If there is time at the end, we'll take questions on anything we covered in the lightning round. But I want to move to the next lightning round. My colleague Bailey Sanchez will talk about EdTech compliance under comprehensive state privacy laws.
Let me just get my screen share. It says host is disabled. Can I get screen sharing if possible?
Yes, sorry.
Okay. Can you guys see my slides?
Yes.
Perfect. Okay. So like Jim said, I'm going to give you a taster into EdTech compliance under comprehensive consumer privacy laws at the state level. Hold on. So as you may know, the US does not have a federal law regulating data privacy. So in the absence of a federal law, we have seen several states over the last few years introduce comprehensive consumer privacy law. So 5 states have been able to pass laws so far. California's has been in effect since 2020 with amendments going into the law in effect in January, and the rest will go into effect next year. So here I've posted the dates for you for your reference. And then like Jim said, we'll share the materials afterwards. So what do we mean when we say comprehensive privacy law? 5 states, California, Colorado, Connecticut, Utah, and Virginia have enacted comprehensive consumer data privacy laws. These laws have several provisions in common, such as the right to access and delete personal information and to opt out of the sale of personal information, among other things. Other provisions require commercial websites or online services to post a privacy policy that describe the type of personal information collected, what information is shared with the third parties, and how consumers can request changes to certain information. In some cases, there's also requirements to complete a data protection impact assessment, and then enforcement for these. It's typically enforced by the state's attorney general. So comparing this with student privacy laws, which either directly regulate EdTech companies or they may regulate entities within the school ecosystem, like school districts and state agencies, or some combination of both. So this is a student privacy boot camp. So you might be wondering, like, Bailey, why did Miles and Jamie even ask you to talk about consumer privacy laws when I just said that they're different from student privacy laws? So first is that they might actually apply to you, which we're going to get into in a bit. The other thing is that, like I said, these laws are going into effect fairly soon. So even if you determine they don't apply to you, you might get questions about whether or not you're in compliance with them. So I think it's worth taking the time to do your due diligence now to determine that and determine what, if any, compliance obligations you have. Because you're probably going to be seeing a lot of news next year about these laws, and you're going to be getting a lot of questions, and you're going to want to know whether or not they apply to you and what your obligations are. So looking at this slide, as you can see, there's a lot of maybes here for EdTech vendors. I use these categories of who it regulates or applies to because these are the questions that we typically ask when we're looking at the state student privacy laws. There's a lot of small differences between the 5 state laws that I'm not going to get into. I think the key question that we should focus on today is determining whether or not it applies to you. So I'm going to give you some kind of questions to work through. And I do want to emphasize that I am a lawyer, but I am not your lawyer. So definitely talk with outside counsel, but I hope that this is a helpful starting point and you have some like tangible takeaways on next steps. And again, it's definitely worth looking at these laws, and it may be very likely that they don't apply to you. Oh, I just lost my slides. Am I still screen sharing?
Yes.
Is it just small? Okay.
Good now.
Cool. So I'm back. Sorry. So first question is B2B, B2C, or both? Do you operate exclusively under contract with schools, or do you also offer products or services to students and families at home? If you operate as a B2C provider outside of schools, you may be covered by these laws. If you engage in processing or controlling of personal data regulated by FERPA, it is still unclear to what extent you may not be covered by these laws. There's some nuance between them. The next big question is revenue threshold. This is specific to California and Utah. Does your gross revenue exceed 25 million? If not, you will not be covered under California and Utah laws. Third category is the extent of your data processing or collection. How many consumers' personal data do you control or process? Do you derive revenue from the sale of personal data? If more than 100,000 consumers' data is processed or controlled in a calendar year, you may be covered under Virginia, Connecticut, Colorado, and Utah's laws. The sale of personal data makes up 50% of your annual revenue, and you control or process personal data of at least 25,000. You may be covered under Virginia, Connecticut, and Colorado laws. Colorado only requires deriving revenue from the sale of personal data with no minimum percentage requirement. This is a big question for EdTech companies. Does your business operate as a nonprofit? So if so, you are likely exempt in Virginia, Utah, and Connecticut. In Colorado, you may actually still be covered. And then in California, you still may be covered as a service provider, contractor, or third party. And then the last bucket is COPPA compliance. Does your business comply with the verifiable parental consent requirements of COPPA? If so, you could be exempt from Virginia, Utah, and Connecticut. Colorado exempts personal data regulated by COPPA only if you demonstrate compliance with COPPA requirements for data collection, processing, and maintenance. So another point of interest to flag, I mostly have talked about that threshold requirement of determining if the law even applies to you, but in terms of risk assessment and determining potential obligations, it is worth noting that some of these comprehensive bills give additional rights and protections to minors. So in Virginia, Colorado, and Connecticut, it treats known child data as sensitive data. In Connecticut, it includes provisions relating to children's privacy and creates an adolescent category of 13 to 15. And so that imposes affirmative consent requirements before a controller sells adolescent data. So I think it's important to remember here that some EdTech companies operate both as a B2B and B2C. And so you might have to do a separate analysis and look at your B2B and then look at your B2C separately. So that was a very quick lightning round overview. I know I have very literally left you with more questions than answers because that is kind of how I structured my presentation. But I think the takeaway here is that when it comes to EdTech companies, there's going to be a lot of nuance with these laws. And I want you to come away with this. Just really, I just wanted you to just be aware that these laws exist. And then maybe call up your outside counsel to help you figure out what your obligations are if you have any at all. And it is possible, again, it could be very possible that you don't have any obligations, which is great. But again, there's a very good chance that you'll be asked questions this next year on what you're like if you're in compliance with the laws, and it's better to have that answer sooner rather than later. So I am going to toss it over to Lauren now.
Hi, everyone. I hope you can see me and hear me because I can't see me. Oh, now I can. Okay. Hi, my name is Lauren Merck. I am a policy counsel here at FPF. I'm also on the youth and education team. And thank you, Bailey, for pulling up thanks for a great presentation, but also thank you for pulling up the infographic that FPF just released entitled Understanding Extended Reality, Technology, and Data Flows. I'm going to keep that up for the duration of my lightning round because what we're talking about today is immersive technology. And specifically, I'm going to focus on XR technology. So first of all, so this is a lightning round. I think everyone's had this little disclaimer at the beginning, but everything I'm going to say today is like a very high level of XR technology and how it might be used in the classroom. The reason we're talking about it is because there is a heightened interest in immersive technology, specifically XR, in classrooms. And many of you your companies might already be using this kind of technology or thinking about if you want to use this technology. Maybe you haven't thought about it, maybe you don't want to, but it's something that is getting a lot of attention. So it's important that you're at least thinking about what the privacy considerations are. I'm going to also add that I am not the immersive tech expert at FPF. I have a baseline knowledge. I work in this space. Kids use this kind of technology, and I focus on kids and student privacy. But the real experts on this are my colleagues, Daniel Barrick and Jameson Spivak. They're the authors of this wonderful infographic, and they are the authors of the blogs that I'm going to put in the chat at the end of my presentation. And I'd highly encourage you to take a look at this infographic in more detail and their two blogs to get a deeper understanding about this technology, what kind of data it uses, and what the privacy considerations are and potential mitigation structures. But at the end of the day, none of us are your lawyers. So definitely also talk to your inside and outside counsel about these things to figure out what the best approach for your business is. And last thing I'll say before I get to the meat of the presentation is that don't worry, you don't have to write down what's on this infographic. If you can't read all the fine print, that's okay. I'm going to share a link to this infographic and the subsequent blogs that my colleagues wrote quickly after my presentation. So you will have all that information, I assure you. Okay, so let's talk about XR. XR, or extended reality, it involves three main types of different products, okay? We've got virtual reality, augmented reality, and mixed reality, and that's what we're talking about now. If you already know this, I apologize. It's going to be a quick, I want to just make sure everybody's on, like, has the baseline knowledge of what we're talking about. So virtual reality, what is it? It's some sort of XR technology that creates a fully immersive environment. Here is what you're probably thinking about when you think of VR, the quote unquote metaverse, digital worlds, anything involving a VR headset where you put on glasses or you put on a headset and you are transported to some kind of digital world where all of your surroundings is different than what is in the physical space. So that's VR. It's oftentimes what people think of when we talk about immersive technology and XR, but that's just one subcategory. Another category of VR is augmented reality. Augmented reality is a type of XR in which you have a view of your physical surroundings with an overlay of digital content. So the classic example for this is Pokemon Go. If you've ever played or you have children who have played, this is where, you can see your physical world. You're in your physical space, but perhaps you have your phone and you're holding it up, and through the screen, you can see, the plant that's in your bedroom through the phone, but then all of a sudden there's an avatar of a Pokemon or you in front of that plant. So that this, again, deals with XR technology that provides a view of your physical surroundings with an overlay of digital content. And mixed reality is probably the one that you might be a little less familiar with. Mixed reality is a type of XR that provides a view of the physical world where digital elements and the physical environments can interact with one another. I'm trying to think of a good education example for this. I guess if you were thinking about perhaps, I don't know if this kind of technology even exists yet, but perhaps there's a digital frog that is in a classroom and you can dissect it. And oftentimes we think about this when we're talking about higher education or medical school, where you might have a virtual heart that is in the physical space, and then you can practice surgery on it. So that's mixed reality. Again, this is probably the one you're less familiar with because it's not as prevalent as VR and AR. All right, so now that we have a baseline knowledge of what I'm talking about when I say XR, let's talk a little bit about why we use it. What are the uses for this? Why is it becoming so popular? How are people going to use it in the future? And some examples include educational purposes, which we'll talk about more in just a second. Shopping, online shopping, employee training, gaming, communication, having virtual meetings, and authentication purposes. And so as you can see, there's a lot, and those are just a few. Like, there's all sorts of potential use cases, and some we might not even know about yet. But all of them do involve quite a bit of data. So XR technologies collect a lot of data, including sensor data, use data, device data, and location data. And this data can come in a lot of different forms, including through eye or body tracking, through audio files, or data and information about one's surroundings and things like that. So this high amount of data that is collected when using XR technologies creates a heightened or additional privacy heightened or even additional privacy and data protection concerns. So that's something to keep in mind. And that kind of leads me to why we're talking about this. Why do you as EdTech vendors or folks who work on these technologies need to know about these heightened data protections? And it's because these XR technology is different than, your traditional EdTech product. If you're going to create an XR EdTech product, it's going to collect different types of data and potentially more sensitive data, depending on the context than maybe your traditional ed tech product that you think about. So what are some ways that, you know, we are hearing about this technology being used in education? We've heard examples of virtual field trips where you can all the students can put on a headset and be transported to maybe a different period in time where they can see the pyramids, or they can be transported to a museum that is out of state from where their school is, something like that. Another example would be remote education. If we went back to remote learning ever, perhaps every student would have a headset and would be in a physical, or be in their physical spaces, but in a virtual space where they could learn and be with their peers and in a classroom. Perhaps that's a use. Skills training. So here we're talking about, you know, that dissection example I gave, mixed reality, or perhaps maybe a trade school that involves, you know, certain kinds of technical skills in which you're practicing a skill, and maybe you practice it in a mixed reality format before you try it on the real thing. And then esports are gaining a lot of popularity, especially at the higher ed level. And that might result in high schools and middle schools starting to adapt those kind of things. And oftentimes esports might involve some sort of XR reality, or could in the future. So as ed tech vendors, you probably know that student privacy is a heavily regulated space. And while there are a lot of potential pedagogical values to using XR in education, or perhaps there could be in the future, the implementation of immersive tech like XR in the classrooms should be done very thoughtfully and with student privacy top of mind. Schools and vendors need to ensure compliance with a lot of laws. I'm sure you've heard that over and over again today. You've heard about all the different state privacy laws that are general consumer that Bailey just spoke about, but there's also state student privacy specific laws. There are federal laws that govern the space. You've got FERPA, you've got COPPA. And so as ed tech vendors, you probably know that this is a regulated space, and schools and vendors are concerned with ensuring compliance with a lot of laws, the federal and state levels, and compliance with these laws needs to be top of mind. This is even more true now. I mean, it should always be top of mind, but as Jim discussed, we're hearing a lot more about heightened attention to ed tech products and children's data. For example, as Jim alluded to, there was the FTC policy statement that came out earlier this year about ed tech and how they are, ed tech companies are subject to COPPA. We just saw an FTC settlement with an ed tech company that wasn't even COPPA related. There is a lot of attention on making sure that kids' data is protected, and a lot of kids' data, student data. And so because XR technologies generally collect a lot of information, and this data can be more sensitive than data that might be collected from your traditional ed tech products, because you might be collecting things like eye tracking or body tracking or things like that, or location data. Student privacy and compliance with the existing regulating framework and future legislation that could pass needs to be top of mind. There are a lot of ways you can mitigate privacy risks. I'm not going to go into all of them because it would depend on the context, and it would depend on how the data is being used. I'm not even sure if the companies here today are using XR technologies or are thinking about it. But I am going to share the blogs of my colleagues that include, one of the blogs is all about like potential mitigation processes. So like I said, this has been a very high level overview of like what this technology is, why you as ed tech vendors might either already be thinking about it or might think about it in the future. This is not me advocating for it to be used in the classroom. It's not me dissuading to not use it in the classrooms. It's just as it becomes more popular and more schools might be interested in adopting it, or more students might be using it in their personal lives, knowing, you know, that this technology is subject to the same student data privacy laws that currently exist and could potentially be subject to more regulation in the future is important. I'll leave you with this final thought. one, an example of why you need to be extra sensitive to the types of state privacy laws when thinking about XR technology is that, some states have bans or moratoriums on biometric collection in schools. And while not all XR collects biometric information, and certainly different statutes define biometric data differently, making sure that you're aware of how the data is being used and making sure that it's in compliance with any biometric law that could exist in the state in which you're operating is another example of why you need to be thinking about this early and during the design process and during the contracting process. So all that to say, there's a lot to think about with this technology. It's getting a lot of attention because it's an interesting technology, and there are pedagogical, there are a lot of people saying that there's pedagogical values from this this kind of technology. But if we're going to implement it in classrooms, we need to do it thoughtfully. We need to do it ethically and with student privacy in mind. Like I said, please reach out to myself or my colleagues, Daniel and Jameson, if you have any follow-up questions or want to talk more about these issues. This has been a very high level overview, and highly recommend taking a look at some of the resources that I'm about to share in the chat. Thank you so much for having me, and I hope you have a lovely rest of the boot camp.
Well, that is actually the last session that we have for the boot camp. So I want to thank you all so much for coming. I do want to let you know.
You're muted.
Oh, sorry. I kept on hitting the button and it just didn't. Anyways, hi, everybody. Thank you so much for joining us today. I hope that it was enlightening and that you had the opportunity to learn some more about this really interesting and changing space.